So it looks like he had a UUMV that was dismissed last week, and then in October we have the terroristic threat here. What happened in the terroristic threat, Morgan, please?
So in the terroristic threat, the complainant and the defendant are in a dating relationship. The complainant told the officers that her and the defendant had gotten into an argument, and the defendant stated,
Give me a second. Okay.
The defendant stated, "I'm going to kill you." He then told her, "I'm going to have someone kill you." And the complainant stated she believes the defendant's threats were credible. And I believe the bond conditions was just no contact. There was a moat put in place, and then no drugs or alcohol, because there were allegations of alcohol use in the offense report.
What would you like, counsel?
Yeah, so I would just ask the court to revisit the no alcohol condition. In the sworn PC statement, there's no allegation of alcohol use. There is a statement in the OR, but there's no sworn statement for the court to make the finding that alcohol was a factor.
I mean, I can still, even if it's not in there, I can still add as a condition of bond that I don't want him drinking. How old are you, sir? Okay. Tell me about the allegation. Normally, when I have a case like this where there's a threat, where there's an assault, where there's something of this nature, and there's either an alcohol, drug, anything like this, I usually do it as a condition that they can. So, Morgan, tell me about, is there something with regards to alcohol?
It was just when the officers arrived, I believe that he was intoxicated. I think they noted in the offense report there was a strong odor of alcohol coming from his person. And I think that's the only allegation of alcohol.
Okay, that's why I did it, because when they get there, they allegedly either see him in some kind of state. And what I want to do is I do it as an effort to prevent any future thing from happening. Do you understand? Dude, if you're sick, we're going to have you go. Are you feeling under the weather?
Just because of
Get out. Like, come on, go. Okay, I'm not prepared to take it off at this time. Perhaps later on, if he's behaving well, we can reapproach. But at this time, I'm not ready yet. It's only been, 60 days, give or take? So, okay, come back. If he's behaved well, then I'll take it off a little bit later, all right? Thanks. Yes, sir.
Yes.
Who do we have here?
This is Ms. Holman, and Ms. Strong is representing also Ms. Diaz. They both were pleased.
Right. Morning, Ms. Holman.
How are you doing, Your Honor?
If you were charged with theft, you're facing up to a year in jail and or a $4,000 fine because of the amount. You guys have worked out an agreement where on your case, they're offering you 8 days in jail with credit for the 8 days that you've done. Good morning, Mr. Medrano. You speak English?
Yes, sir. Well, my last name is Diaz.
This is Diaz here.
Oh, sorry.
That's okay. Both of you guys are giving up a lot of rights by entering into the agreement that you guys have now. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you guys are not citizens, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do, Ms. Holman?
Yes, Your Honor.
Like I said, you're charged with the theft. You're facing up to a year in jail and or a $4,000 fine. The thing that you need to understand, ma'am, is that this is an enhanceable offense, meaning that if you continue to pick these up, at some point they will charge you with a felony and you're looking at days instead of years.
Yes, Your Honor.
8 days in jail, credit for the 8 days that you've done. Is this what you want to do, ma'am?
Yes, Your Honor.
How do you plead to the offense of theft? Guilty?
I plead guilty, Your Honor.
I will find you guilty, sentence you to 8 days in jail, give you credit for the 8. Good luck to you, man.
Thank you so much.
Mr. Diaz, you are charged with criminal trespass. You've worked out an agreement. They're offering you 27 days in jail, credit for the 9 days that you've done. Is this what you want to do? How do you plead to the offense? Guilty or not guilty? I will find you guilty. I'll send you to the agreement. Good luck to you, sir.
This is an off docket. Tell me when you're ready for the case number.
Tell me.
254-3247, Daniel Arevalo. This is a case of an ounce of prevention, hopefully is better than a pound of cure. I got on the case after he'd already appeared in court and got his bond condition. He has random urinalysis. He travels a lot.
What does he do for work?
September, 7 days, 18 days in October, 21 days in November, what I would propose.
What does he do for work?
Construction, and would you like for him to?
Sure.
Come on up.
So this is what we normally do when they get called upon. They have to go to a Quest Diagnostics, wherever they are. Quest is all over the country, and they need a test at a Quest because it's a reputable lab.
I mean, we're talking Montana and Wyoming at times. What I was going to suggest is, could he call pretrial on Monday and give them his schedule and take a portable breath device?
I'm okay with that. Sure.
Okay.
Yes.
That way, they can work.
I'm happy to do it.
schedule,
Yep.
And it's a DWI, so we're making sure he doesn't.
Done.
Okay.
Sounds good with me.
Let the pretrial know.
Yeah,
So portable, no more mandatories, correct?
correct. Waive the fee. Are you ready?
Yes.
It's 254-3247. Okay, good luck.
Thank you, Your Honor.
Thank you. All right, guys.
Like I say, ounce of prevention.
Okay, come on.
Luis,
Come on in.
Mr. Madrano, Your Honor. Good morning, Judge.
Nieto,
Are we doing a plea?
Yes, Your Honor.
Okay. All right, now, Mr. Medrano, you were charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 30 days in jail with credit for the 12 days that you've done. It looks like the state is moving to reduce it to a DWI first. Mr. Medrano, what you need to understand, 1 and 1 make 2. 2 and 1 make 3. So the next time you pick a DWI, it will be a third, and you will be looking at a felony charge. A minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? If I were you, I wouldn't get in the car even if you've had a sip of alcohol because you were taking a humongous risk.
yeah, this is.
Do you understand? You are giving up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record and you can never take it off. Do you understand?
Yes.
Is this what you want to do?
Yes.
How do you plead to the offense of driving while intoxicated, guilty or not guilty? I will find you guilty. I'm going to suspend your ability to drive for 1 year. Do not drive until you get a license. Good luck, sir. You can waive the fee and then the surcharge, which is $6,000. So $6,000 plus whatever the court cost is to waive.
Thank you, Your Honor.
Thank you. Yes, sir. Thanks. And you've now picked up a new case. Your bond now gets revoked. It goes with you. No, sir. We'll appoint him a lawyer today.
So,
Speak English, sir.
Yes, I will.
Morning, Mr. Caceres. Mr. Caceres, you are in front of us now because you have a fugitive case. You are wanted out of state of Connecticut for sexual assault. And he is already waived.
Yes, Judge.
And where are we at now?
So, Judge, this was originally set today, but on Friday, on a notification from the demanding jurisdiction, they requested an extension from today to the 3rd. They didn't receive notice, which
Oh,
I don't believe this was addressed
Yeah.
on Friday, but they've since corrected the issue with the original fax number not reaching the detective's desk for extradition. And so they've now corrected it where this won't happen again.
So are you saying that Harris County did not fax Connecticut?
No, they did fax Connecticut, but the fax numbers that they sent it to is it has to go through, I can't remember if the name is inspector or adjuster, but there is a figurehead that has to flow through before it reaches the detective's desk, the actual extradition detective. And so on the third attempt, when there was no response, is our sheriff's office reached out to their sheriff's office and finally got someone on the phone. When they were notified that same day, within, I would assume, a couple of hours, because it was still the morning, the detective immediately called Amy, who then notified me, and I talked to the detective within hours of being notified. And from then, they asked an extension to the 3rd to pick him up. For this offense, they have been investigating since 2021. The warrant issued in 2022 is that they've been pursuing this defendant for quite a long time. And again, this was learned after our approach. I'm speaking with the detective, is that they weren't aware, they had a possible suspicion he might be in Texas, but they weren't even aware he was here. But due to the severity, the nature of the offense, where, to recap Friday, is that this was closer to a burglary of habitation, 1st degree, where a sexual assault was committed after forcing himself into the home of someone that he knew. This was not from what they allege, it's not a dating relationship, but someone he's familiar with, is that because of the severity of the offense and the fact that the warrant is so old, is that the detectives believe they are not confident that he will self-surrender. And because they've already confirmed, and they sent another confirmation email this morning that they are able to secure and pick him up this Friday, is that we request no bond for this offense and the extension.
Judge, if I may, so whatever the charges might be, it could be murder. It can't be murder because you can't let
Right.
bond. The point is he's presumed innocent. So without anything else, he is innocent as he stands here. No evidence is being presented. So if we're talking about the severity of something, he is presumed innocent. He is innocent of that as of right now, until he gets over there to that jurisdiction and they find him guilty of that. So presuming he's innocent, talking about the severity of a charge doesn't really have an effect on this fugitive case, because there are 2 things that he's got in place, 2 things that he needs to make a decision on, whether to waive or whether to fight formally his extradition. The waiver says, what he agreed to says, they have 14 days. It is ordered for the sheriff to hold him for no more than 14 days of the date this was signed. This is the actual order signed by the court. This is what he agreed to, signed by him, signed by you, the judge. And so this is the agreement. The fact that somebody didn't send a fax to the correct number, it doesn't say, but if we send the fax to the wrong number, you get to hold them for 3 extra days. It says 14 days. This is what he signed up for. This is what's ordered. This is what I say should stand, and this is what I say should allow him to get out today. If they didn't do their due diligence for this, it's not on my client. He signed up for this.
So let me explain to you how things work, Mr. Caceres, is that the 14 days is a courtesy. Statutorily, by statute, we can hold you for 30 days. Normally, and it has become custom that we do 14 days because of the overcrowding that we have in Harris County. We have so many people in custody, 8,000, 9,000, up to 10,000 people at any given time in and out of our jails. And because of that, as a courtesy, we do 14 days. Now, many times I grant extensions, I don't grant extensions. A lot of times there are several factors that is determinant of whether I grant an extension or not. One of the things has there ever been an extension before? Number 2, the nature of the charge. Number 3, have you ever had a fugitive case before? And so these are things that I look at as to whether to grant an extension or not.
May I please speak?
Well, I don't know. You may want to talk to your lawyer. The thing is this, look, I don't want you to talk about the original case, okay? Because the thing is that I live stream these proceedings, right? And so I don't want you to say something that you put your foot into your mouth, because here, the only thing that we're discussing is whether I should set a bond for you to get out, for you to go turn yourself in. That warrant, even if I let you out today, that warrant will eternally be there, and it'll always be out there until you go turn yourself in. The only thing we're discussing now is whether I should set a bond to let you go turn yourself in, and I don't know, Because are you a flight risk? I don't know. The only thing I know is that you're charged with a very serious case. It's sexual assault. And so to me, the protection of my community is paramount, number one. Number two, the other question I have is if we let you out, are you going to go turn yourself in? Everyone tells me that they're going to go do
Ask
that.
my family. Sitting in court, and they are the one. They're the one supporting me, and I know 100% they're gonna support me to turn myself in. That's why they're still here, and I'm still the last one. And yes, I didn't know about the fugitive warrant that I had. And yes, I'm willing to turn myself in because I'm innocent.
You need to fight those charges regardless because they're very serious charges. So Dave, what day did you say that they're going to come
This
pick
Friday, and I forgot to include, I know typically the court permits over objection for the 3 days, but considering the New Year's Eve is holiday, that's how I also included the
So are they going to be here Thursday and we reset to Friday?
on Friday. And so that's why the discussion on last Friday was having it on the 6th, but if they're not here by Friday morning, is that you would potentially grant a bond.
So this is what we had planned to do was I was going to give them an extension until Friday morning, right? If they don't come by Friday in the morning, I'm giving you a PR bond.
I came to visit my family for the holidays. I wasn't able to enjoy that. I'm willing to turn myself in, but I would like to be with my family for the New Year's to start with a strong
Concern is not my concern, and my only concern is I want you to get back to Connecticut.
And I will, but I need my family. I need to today, as the paper says, I signed for 14 days, and I would like to have a time with my family to look for the bond, to look for them to go forward with turning myself into Connecticut, but not like waiting for Friday.
Let me make one thing clear to you. This isn't about giving you a PR bond. If I were to set you a bond now, it's going to be something substantial, meaning a high bond into the 5 digits to ensure that you go back to Connecticut. This isn't about giving you a PR bond. If they fail to come get you by Friday, I'm going to give you a PR bond because they have fallen on their word twice and I'm not going to do it. Now, if I were to set you a bond now, I mean, it's over 10,000, something like that to that nature. And because it's a fugitive case, there's no 10%. You're probably going to have to pony up 90 to 100% of it because you are an inherent flight risk because it's a fugitive case. So there's none of this 10% where you pay $1,000 and you're going to get out. No. In these types of cases, when we have fugitive cases, I normally set bonds, 5,000, 10,000. I've set bonds at 50,000. I've set a bond at 100,000, depending on the nature, severity, how many criminal history. So this isn't about just letting you out now, willy-nilly. No, I would set you a bond and it's going to be a substantial bond because I have to know if I'm going to let you out, there's got to be enough blood in there that you're going to actually go back and not just try to flake out. Because if you take off and you don't come back, all that money's gone. So,
okay. But the 14 days were exactly what I signed for.
Remember, it is a courtesy. Statutorily, we can hold you here 30 days. Okay.
To address the legal part of it, if your client is stating that he is withdrawing the waiver after today, then at that point, if you're considering a refusal, then we'll start the governor's warrant process and we'll hold him to 90 days. So if that's what your client is requesting, just in terms of your argument, because you were stating 14 days, that's true. If you want to, at the end, then revoke it, then we'll request an extension to 90 days and get the governor's warrant. So.
Judge, my argument is what he signed, what the order states in the documents filed in this case. This is what's filed in
I
every
get it.
single-
I understand that. But there's sometimes extenuating circumstances. Things happen.
Not faxing it to a certain person is not a good excuse, Judge. He's sitting there waiting 14 days just because somebody didn't do their job. That should not fall on him and cost him 5 extra days. That's 5 days this man is sitting in jail. 5 extra days just because somebody didn't send the facts to the correct person. This
Get it.
isn't the first time.
It's a courtesy.
Okay.
We can hold you 30 days. The 14 days, I don't have to give anyone 14 days. I can hold everyone 30 days if I wanted to. 14 is a courtesy. I've told you now that I'm going to give them until Friday. If they don't come here Friday morning, I'm letting you out. And now it's on them. And I don't care. I'm going to give you a free bond on Friday if they don't come pick you up. But if I'm going to set you a bond now, the first thing that's going to happen is you have to withdraw your waiver. All the 14 days that you've accrued so far goes out the window. You lose all the time that you've accrued. If you're unable to make the bond, you've lost all that time. Then they're going to get another, another couple weeks to come get you. So give it till Friday. If they're not here, then I'll give you a PR bond. If they come here by that time, then you get up and you go fight the charges in Connecticut. Now, when you get to Connecticut, you can also, ask for a bond there. They can set you a bond there. But, the money that you would spend here just to get out, it's probably, use that to hire yourself a great lawyer there. Because the thing is that here, it's just a little wait. That in Connecticut, that's what you really got to worry about. This is peanuts. You go there, lean on your family to get you the best lawyer you can get in Connecticut so you can fight that case. That's where the concern should lie.
Thank you, Your Honor.
Remember, when you get on that phone in the jail, every phone call is recorded. Be careful what you say. Be careful who you talk to. There's a lot of jailhouse lawyers over there. They're going to tell you this, they're going to tell you that. Listen to Ricardo. He's going to direct you the best, and then we'll reset this to Friday. If they don't come Friday, I'm giving them a PR bond, and I don't give it.
Right, I'm with you, but it was one, remember, because the holdover issue is that it has to be set.
We'll set it to Monday,
Right,
but
otherwise he's gonna be brought up in.
you'll be here Friday, right? Okay, we'll look in the system if they've come get you Friday morning. If not, if they haven't come get you, we got to set a time.
But still, actually, they emailed confirming, let me see if I can get a time, because they have to send it to Central Records for the pickup. So I'll see if they're able to
We brought you here today so that you could hear what's going on, because we wanted to keep you in the loop so you know what's going on.
Thank you, Your Honor.
Okay? That's why we brought you here today, so you can hear, so you know you're in the know, because this is your case. You need to know what's happening.
hopefully they'll respond soon. I just emailed the inspector over there. Inspector, so it is inspector. And so hopefully he'll get back to me soon. And then
If you want, we can roll it to tomorrow. That way gives you a little bit more time to get a concrete and firm time.
I have the date, right? If it's just the time, I mean, I have no issue with rolling it just to check the time, but every day that rolls over, he has to get brought up in the morning really early. So
what I want to do is I want to be able to commit them to a specific time on Friday, so I know I can start working on a PR bond, because I'm not giving them until 5 p.m. Friday. You know, it's got to be in the morning, and they got to come get you. And if they don't by 10:30, then at that point I start working the PR bond for you.
Why don't we just set it for 10:30?
I mean, if I get a different time, then obviously I'll email you and I'll email the court. And so
It's got to be something reasonable, morning-ish.
I think they indicated morning, but obviously until they confirm with our central records.
I want to know from them specifically so that they can say, "Oh man, you didn't tell us that time." And no.
Right. I want you had one for a specific request for an
I
affidavit.
want them to commit so that they know if they're not here by that time, he's going bye-bye.
The only concern would be is if we don't do it by the time court is done with.
That's why I'm trying to commit them to a time before court is done, so that they can't.
Perfect.
It's on them. There's no one else that they can blame.
Okay. Yeah.
We can bring them back tomorrow if you want to do maybe. We're off Wednesday, right?
Yes, Judge.
Thursday, whatever you want, or we can email and then you can.
We can email and just, unless they wants to.
Well, I'm emailing the detective now because I emailed the inspector originally. I probably
They
should.
may not respond within,
Well, we can approach on it tomorrow.
Yeah, of course.
We don't need to bring Mr.
That's what I mean. It's
Done.
Yeah.
That's what we're doing. We're going to pick a time Friday for them to come pick you up so that they are in agreement with. So if they don't come here by that time, you're giving the PR bond.
Thank you so much.
Okay? Okay, man.
Thank you.
Okay. Thank you, Judge.
All right.
So,
And Ricardo, I guess you'll explain.
Yeah, I'll talk to the family. I'll let them know what's going
so I'll be here tomorrow, and I'll be here, but I'm out Friday though. So obviously I'm going to leave it to Amy. Stan is covering for me Friday, and Katie's covering for me Monday and Tuesday. But obviously all these will be in the notes, and then any emails
You out until when?
I'm out. I'll be back next Wednesday. So, but it'll have it all in the notes for.
You're gonna be in the same division?
Oh yes, yeah. No, sorry. Anniversary trip.
No, but I mean, with the new administration that comes in, will you be staying?
Because somebody hasn't told me something. The expectation is I'm remaining where I'm supposed to be. So,
Great.
knock on wood. I probably shouldn't have said that out loud. But yes, nothing should change.
Ricardo, come on, man. I got a jet.
Judge, approaching on Jose Caceres, he had a 11:15 pickup time.
Yay or nay?
Yeah, he's done.
Okay,
Okay.
great.
Okay, thank you, Judge.
Who are you? Come on up. You can come too. Why on two different sides? You embarrassed to be with your mom? Oh, okay.
I separate
Got it.
family and spectators.
Okay. Good morning, Mr. Hardy.
How you doing?
Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. Shh. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of a two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant, the driver of the vehicle, and observed a strong odor of marijuana and had the defendant exit the motor vehicle. A PC search was conducted and the officer located 3.5 in the driver's side door and one blue package with Oops All Berry on the front containing green leafy substance on the rear driver's side floorboard, one red package with Fruity Pebbles on the front containing a green leafy substance in the back seat, and two clear plastic baggies containing green leafy substance under the front right passenger seat. The officer also observed one burnt marijuana cigar behind the front passenger seat and one small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road. So he was out.
On earth are you going to know that you're parking more than 18 inches? What time of day or night was this?
Your Honor.
Is it parking while black now? Come on.
Yeah.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block of Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana.
Oh, but because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presuming the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, a black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Regarding the 18 inches from the curb, sir, is that the
Yeah.
issue of what we're talking about?
Yeah, because they come to him because he comes to them. Right, they're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
In Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night was this?
I didn't see that, wrong. Take a second. At 4 in the morning.
And Your Honor, I
4 in the
found,
morning.
4:30 a.m.
And he can delineate at 4 in the morning that parking 18 inches from a curb.
and I found the regulation, the statute in the transportation code where it says you have to park within 18 inches.
At 4 in the morning, you can tell.
Your Honor, the officer was,
Yes, I don't think so. All right, I'm going to find no probable cause. All right, guys, be careful, right? You know, they're always out there. Just be careful. Do something with your life. Knowledge is power. Get into school, get an education, do something with your life. Life is hard as it is. And it only gets more difficult the older you get. All right? Okay, guys, please.
And we'll be sure to call the officer on this case to
Whatever you need.
understand why he did, in fact, pull them over for this amount of space.
a traffic stop was initiated, and the officer observed the driver leaning over the console, trying to conceal something next to the console in the front passenger seat. The driver and the passenger did not see the officer as he was standing near the driver window, where the officer observed the driver have his hand between the front seat and the center console. The officer ordered the occupants out of the vehicle and observed a plastic bag containing a green leafy substance with an odor of marijuana as the front passenger exited. And the front passenger immediately took off running, and the defendant, the driver of the vehicle, stated he only knew the passenger to be named Junior. The weight of the marijuana was 0.3915 ounces.
Judge, looking at the totality of the circumstances, the state has not been able to allege enough probable cause that my client knew or intended that there was marijuana in his possession. I understand that the allegations say that there was some type of furtive movement, but my client yielded to law enforcement show of authority, and then gave law enforcement his identification. The passenger ends up leaving law enforcement. He stays there. And again, there's not enough to establish that he knew or intended that there was weed in his car. The allegations also don't, pinpoint where the marijuana actually was. So this was this was unbeknownst to my client, Judge.
So he comes up, officer comes up to the car, and he sees him trying to conceal.
Yes.
Right?
I don't think that, I believe the allegations say that that's what the officer maybe seems to believe, but after further review, there's nothing that says that's definitive or that's even probable cause. For all we know, he was rummaging around to give him his ID, which he did. That's why he got picked up.
No, but he says he's got a plastic bag and he's trying to put a plastic bag behind the console.
Because, Your Honor, they found his hand between the front seat and the center console. They observed his hand in between the console. As where
Was
they
it a
saw,
plastic bag too?
it says that they observed a plastic bag containing the green leafy substance. Yes, Your Honor. And that was after the passenger exited. So when they walked up, they saw him with his hand in between the console and the front seat, where they observed him trying to conceal something.
So, Judge, in the DIMS, it says, quote, as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance. The way I'm reading that, Judge, is that's more attributable to the passenger and the alleged marijuana that was near his person than it was my client. Again, the rummaging around, Judge, I don't think there's enough of a nexus to establish that. My client yielded to law enforcement show of authority. He gave law enforcement his ID. While he's standing there submitting to law enforcement show of authority, the guy with his hands up with the marijuana that's around him leaves. So if anything, this should be attributable to the passenger.
Saying that the weed is the passenger's client, not your client. That's what you're saying.
Yes, and based on the allegations, Judge, there's not enough probable cause that attributes my client knew or intended that marijuana was in his possession, when everything just as much points to someone who ran away from the cops.
Hit the gyms again, and then who is the one who's allegedly hiding things? Is it?
It's the driver, Your Honor, which is the defendant.
Right.
The officer said the officer observed the driver have his hand between the front seat and the center console, and previously.
Okay, wait. So between the front seat
in the center console, and the officer said, I observed the driver leaning over the console trying to conceal something next to the console and front seat passenger. And that's where he observed his hand in the front seat, between the front seat passenger and the console. So the officer observed him trying to conceal something. And all the DIM says in regard to the passenger and the marijuana is that as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance smelling of marijuana. It doesn't say anything in regard to it being solely in the passenger's area, because it said previously he was trying to conceal something.
Again, my apologies, Counsel. Judge, if I may.
he's actively trying to conceal a plastic bag?
Your Honor, so with this situation, when we were briefly speaking, allegedly this driver and passenger don't know each other, but then in this situation, should this person, the defendant, be pulled over for speeding, one would think he'd keep his hands 10 and 2 and not be trying to conceal something. So that's where we're at. And if you didn't know that didn't know the passenger, didn't know that they had the marijuana, didn't know anything about the marijuana, why are you concealing? Why aren't you keeping your hands at 10 and 2?
Judge, anytime somebody's driving, again, I think there's a reasonable inference that goes just as much to my client was trying to go through his belongings, give law enforcement the correct identification so that he could submit to law enforcement show of authority. Again, just because it says concealed doesn't mean that there's enough allegations to actually substantiate that anything was concealed. If anything...
No, but is that enough for him to continue and to investigate further? Right. His allegation is, I come up to the car and I actively see someone trying to conceal something. So at that point, I'm going to investigate further.
My issue is not, law enforcement had the right to further investigate the case. We understand that my client was speeding, Judge. My issue, though, is that they're saying that the front seat passenger is getting out of the vehicle and then he sees weed as the front seat passenger gets out. My client is already...
So who do they both have weed? Is that what happened here? Do they both end up with...
My understanding, Judge, is that there's enough probable cause that actually goes toward the passenger being in possession of the
Did they find weed where he was trying to conceal whatever he was trying to allegedly conceal?
The allegations are not clear about that, Judge, which is why...
Admittedly, they are not clear about that because all it says is that as the front seat passenger exited, they observed the plastic bags. But previously, they did say...
Where?
It does not say, Your Honor.
That sucks. Then write a better report.
It does, but they did say concealing something.
I need to know, where is the weed in the front seat passenger?
There are enough affirmative links still because he's the operator of the vehicle and is within his wingspan, and they saw the previous furtive movements being made to draw the inference of knowledge. So there's enough affirmative links between him and the contraband for probable cause.
I don't work on hunches.
It's not a
hunches here. I mean, it's not that hard to write in the report. Well, I saw weed where I found his furtive movements. You know?
Yes, Your Honor. They didn't clarify that, but they did.
Then too bad, so sad. Sorry.
I will say, Your Honor, this did just happen 2 days ago. If we could wait to get the offense report, maybe he articulated it.
No, I mean, I he's in custody. I don't want to wait 2 days because he's in custody. If he was on bond, man, perhaps, but he's in custody. He's in jail, just sitting there. You know, I'm with you. Okay.
Thank you, Judge Fleischer.
We're done.
Yeah. I mean, Alex, I'm not asking for much, just a little clarity. That's it. You know, and I bet you now, hopefully, never make that mistake again.
Order in the court for a plea.
Good morning, Mr. Thompson.
Good morning.
Sir, you're charged with driving while intoxicated. Second offense. This is a Class A misdemeanor. You're facing up to a year in jail and/or a $4,000 fine. It looks like it's being reduced to a first. It is, right? So now you're facing up to 6 months in jail and/or a $2,000 fine. But what you need to understand, still in the eyes of the law, this is number 2. And if you pick up another one, you'll be facing a third. And a third, you're facing up to 2 years in prison. Up to 10 years in prison, minimum of 2, maximum of 10. If I were you, even if you've had a freaking sip of alcohol, I wouldn't get into a car because you're taking a humongous risk. Do you understand?
Yes, sir.
All officers look, if you smell funky and then they look at your record, that's all they care about. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Do you understand?
Yes, Your Honor.
This is what you want to do.
Yes, Your Honor.
For you to complete this, you're entering into a probation with us. It's going to go on your record. This is a straight probation. And for you to complete it successfully, you must do a repeat offender DWI education class. 2 victim impact panels, a TRAS, which is an evaluation to see what other conditions you may need. If they assess further conditions, they might. It could be intensive outpatient treatment. It could be supportive outpatient treatment. If they assess further conditions, you must fulfill those conditions. No breath test refusal. So if you were pulled over in a car and you take a breath, and an officer asks you to take a breath test, you have to do it. If you don't, you're in violation of probation. Substance abuse treatment, $100 one-time donation to MAD, no drugs, no alcohol, and a guardian interlock. Is this how you understand the agreement?
Yes, sir.
How do you plead to the offense of driving while intoxicated, guilty or not guilty?
Guilty.
I will find you guilty. I will send it you to the agreement. What do you do in life, Mr. Thompson?
Bartending at a hotel.
Ugh, that's not good.
Judge, he's been on interlock for almost a year now. Portable device, blown 3 times a day. He hasn't had one failed test.
Okay.
He has, so he's been doing very well.
My only issue is that temptation is so high when you work in that kind of environment. You know, when you work in the restaurant industry, everyone tends to booze it up. You just got to be very careful. You know, for the next 18 months, you're on paper. You can't do anything. You end up drinking. I'm going to issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out here and we're going to talk. And it's possible I sentence you and put you in jail for 6 months. You understand?
I understand. Yes, sir.
But the most important thing is that for the next 50 years of your life, even if you've had a sip of alcohol, I wouldn't get into a car and drive because you're going to get hosed. If you thought it was expensive now, wait till you get to felony court. Everything quadruples in cost, time, everything. So what about the fee?
Fine.
Yeah.
On probation?
No. There's a supervisory fee for the DPS surcharge. It's a $6,000 fee.
Attached to a probation? I thought that was only for a straight conviction,
Nope.
Judge. On a jail time.
It is a conviction.
It's on a jail time conviction. The state traffic funds for a jail time conviction.
Show me. But from what I understand, with this kind of case, there's a $6,000 surcharge that we're supposed to tack on.
I
The
was
DPS surcharge.
under the impression that the
Show me otherwise. And I
mandatory
won't.
license suspension.
When what they've told me on convictions here, when you plead to a DWI, there's a surcharge. On a first, it's $3,000. On a 15 with a first, it's $4,500. On a second DWI, it's a $6,000
So
surcharge.
technically, because this is charged as a first,
Right. No, you're right. It's 3,000. Is this a 15?
is it a what? How's it put?
Yeah, it is. Is it true or untrue that you had a 0.15 or above?
Yes, Your Honor.
So true to that enhancement then? Yeah. Okay. So find me that it's not true. Otherwise, I'm, just show me. Or just take a seat for me. We'll be back.
Looking at that, we'll be right back. I looked it up, Judge. You're correct. There's no caveat for probation
So
versus.
I gotta hit him with a $3,500 fee.
Actually, just to be 100% judge, it has to be 6,000 because it is over a 0.15 in the code actually
No,
states.
it's 3,500. It is. I'm gonna do the 3,500. Okay. We do it through probation, so it'll be
Okay.
like maybe $100 a month,
$100 a month?
right?
That's doable.
But just tell him he's got to do it, you know?
Fantastic.
And then hopefully this way he gets the message.
Absolutely.
Cost you big, don't come back.
I've spoken with him thoroughly about the consequences of getting another. So, I mean, I appreciate it, Judge.
If he's driving,
Yes, he's not driving.
Okay.
He lives very close to where he works, he walks or rides a bicycle.
let him know that he cannot drive without a guardian interlock, otherwise he's going to get hosed. Okay?
100%.
Okay. All
Got
right.
you, Judge. Have a happy New Year.
Two things. De La Paz.
Yes.
Mr. De La Paz, you are charged with driving while intoxicated. Are you ready? Okay. Mr. De La Paz, you were charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. It's also alleged that you had a breath alcohol of a 0.15 or above. Shh.
Quiet!
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On December 23rd, 2024, the officer observed a stalled vehicle with the defendant behind the wheel asleep at an intersection. The defendant had his foot on the brake, and the vehicle was on and in drive. The officer observed two beer bottles in the center console, one half empty,
Drinking
and
while driving.
the officer observed a strong odor of an alcoholic beverage, watery eyes, slurred speech, and swaying. Standard field sobriety tests were conducted. HGN 4 out of 6, one leg stand 2 out of 4, walk and turn 5 out of 8. The DIC was read and the defendant consented to breath. The results were 0.159 and 0.153.
Mr. De La Paz, I'm going to find that there's probable cause to go forward with your case. I am now taking away your privilege to drive. You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand? I don't care if you school, groceries, work, kids. I don't care. You drive, you will stay with me, possibly for a very long time. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you will be shipped off to immigration. Do you understand?
Yes, I understand.
I'm also ordering you, as a condition of your bond, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a scram ankle monitor on you so I know that you're not consuming alcohol. You consume alcohol, into jail you will go. No more PR bonds for you. Come up, Mr. Martinez.
And it's BVR. I do have some documentation of some stuff, and he did contact.
I am so unhappy with you, Mr. Martinez. I don't think I can even freaking see straight. You have a theft of a firearm, a driving while intoxicated, a failure to identify oneself to a peace officer as a fugitive from justice, a theft case, an evading case. And I put strict bond conditions on you, and now you're here with a violation. Enlighten me, Greg.
So if I'm not, I don't have the BVR in front of me.
Oh, let me give it to you. Hold on.
If I'm not mistaken, however, the dates are the 23rd and 26th. Is that correct? Roughly.
I gave him a 9 p.m. to 6 a.m. curfew, and he got home at 10 o'clock on one day. And then another day, he took off as well.
Okay. So it does say here after he did go to the bail bondsman. Okay. And he contacted them, let them know. So he was on his way home. So, I mean, Are they trying to ding him for a 9:36, 9:48 stop on the way home?
I think that there's plenty of times in the day that you can go visit your bail bondsman. It's not you don't have to go at 10 o'clock at night.
I don't drive. I can't drive. And my wife gets out at 7:30. She picks up the kids, and then I told her to take me, and that's the only
I've
time I
got
have.
concrete evidence right here on a GPS monitor.
He's saying his wife drove him to the bail bond and then they were on their way home.
Yeah, but I call every time.
And then he didn't take off. It was an issue with his boot, and he did contact them, and they sent him a text to report to 49 San Jacinto to have the device inspected by a technician, and he responded to them, and he went in to get it correct. He wasn't trying to cut it off. He wasn't trying to break it. It was.
That's not the issue. The issue is that he's staying out late.
Well, he went to the bail bondsman. He was going home.
He has a curfew of 9 p.m. That's it. I don't care if you're going to visit Jesus. If a curfew is a curfew, and you're supposed to stick to the curfew.
When did you get out?
That's it.
It was like 2 weeks ago, man.
Can you download the
So
rest of
this
the
is when
data?
you got out on bond?
That was the
Alicia,
These dates, man. What time? When did you get out on bond?
download the rest of the data. I'd like to see what else is going on with him.
It was December 14th.
No, since, I guess,
On 12/19?
since December, how's he been otherwise? Take us.
That time.
That was the one time that
Nice. I'm gonna let you,
she gets out at 7:30. That's why.
Yeah, but why'd you go that time?
Greg,
Because that's one of the
at the line. Can you guys talk about it? Take a seat for me in the jury box,
Okay.
please. Hey, Greg,
Hey, Judge.
what's the word?
Mr. Martinez is back.
For THC, benzodiazepines, and cocaine.
But I haven't done those, sir. Like, I haven't.
Sorry, Charlie. Goes with you. Sorry, Greg.
What was the third one, Judge?
Cocaine.
Oh, okay.
That's it.
What is the reset date, Your Honor?
He'll pop up on tomorrow's docket.
So Thursday or Friday, whatever.
So yeah, he'll pop up on Thursday's docket. I'm gonna revoke the bonds. I don't know what they're set at now.
I'm in your court Thursday, so sounds good, Judge. I'll be there. All right,
Okay.
thanks.
Thanks, dude.
Yeah, have a happy New Year, Judge. Thank you.
You too. Hey, have a great New Year. Sorry, bud. Good morning.
Good morning. I'm approaching on Shredwell, Brianna Shredwell.
Treadwell. Okay.
Homes here.
It's not old.
It's not, no, it's, but this is more so addressing the conditions that TRAS recommends.
Oh, she has 2 open DWIs.
Yes.
Right. What are they?
One from September and then October.
So they probably want inpatient treatment. You know, and I'm going to tell you that Brianna Treadwell, come up.
This way, man.
Hey, and I'm so glad that Mr. Butler, you're here because come up. Every time, I mean, I can't be that conclusive, but so many times when we do a TRAS, because I have clinicians that interview people and make recommendations, so many times when I don't follow those conditions, I get burned. I had one today that recommended inpatient treatment on an individual. He now put 2 people in the hospital and picked up a 3rd DWI, a felony DWI, and he's sitting in custody at a $75,000 bond because I didn't follow the TRAS that recommended inpatient treatment. And now 2 people are in the hospital, serious injuries because of it. Another gentleman here back there, we did a TRAS, I didn't follow it, picks up another DWI with another pending, and then just the TRASs are there for a purpose. We have professionals, we have clinicians that interview and make a call what they think the best outcome is for a certain individual. Now, you have 2 open DWIs, and they take all these things into consideration, how to move forward with the case, because believe it or not, we want the best for you. We want you to leave better than you came here. And just so many times when I deviate from that TRAS, we end up getting burned. I can't tell you over and over and over. And that's the last thing that we want. What did it recommend? Yeah.
So, Your Honor, Ms. Treadwell, she has 2 young daughters. One of them special needs, who requires occupational therapy and speech therapy. That happens once a week. The other one is middle school aged. Ms. Treadwell, she was in custody for about a month and a half, I believe. And it was very difficult, extremely difficult for her family to even try to coordinate things with her daughters. And then as well to keep Miss Treadwell with her home. And so Ms. Treadwell, she needs to work. She has bills, as everyone does, and all of these other circumstances with the children. At least looking at it, and from Ms. Treadwell's perspective, it seems impossible for her to go into treatment inpatient, and it's hard to see that other side. What does that other side look like for her? And so the kids were staying with her parents. Her mother just got surgery, hip surgery, and they broke her femur in doing so. So she's out of commission. Her brother was staying with her parents at the time. He is about to now move to Chicago as of next week. So they don't have the same system as they had in place while she was in custody. She was very much in custody based on, her parents believed that, this was an issue. Just as, on its face, you're looking at it, it's definitely an issue. It's not to say that she has paid her price at all, but and her intention is to do what's needed. She has explored all of these options, or with respect to even with the, is it Vivitrol Vivitrol. She has explored options through Access. So she has been making those steps. My belief is that she has, I don't want to say learned her lesson, but she has.
I don't believe it for a second. Well, I'm telling you, she has 2 open DWIs. Mm-hmm. And every time I deviate from the TRASs, we get burned. And now, just today, 2 people in the hospital because we deviated from the SATIF, and homeboy picked up a 3rd DWI.
Yeah, and I was made aware of that prior to us even approaching.
Last thing I want is for you, because the idea of Hue is that you are able to learn how to deal with the stresses and the stressors in your life, so that alcohol, substances don't become a coping mechanism, right? And I don't know what to tell you, but actions have consequences. And I understand that, you have a lot of things in your life that are going on now. The only thing I can tell you is that your case is only 118 days old, so it's not too old. I will give you time, right, so that you can get everything in order. But I'm going to be very hard pressed to move away from the TRAS.
Understood.
Just we have time, right? So you have a couple months. I'm willing to give you a couple months to, get things in order, but you have 2 open DWIs. The last thing we want is you to go kill someone end up with a felony charge, because I'm telling you, the next one, you're looking at 2 to 10 in the penitentiary. If you think Hue for a month and a half is bad, that you're gone, consider 10 years. That's the next. So there's nothing that needs to be done immediate at this point. We've got time. Time is on your side for now, but that time's going to run. And the other thing is that from what I've learned being here, the longer you take to address, the worse things become. So we can reset at 30 days, okay? But at some point we have to address it, right? So just be ready, okay? How long is the Hue program?
The wait list for Hue is a week.
Okay, and then, but actual Hue, the actual program, how long is when you're in? Wow, 6 months.
6 months.
So 3 if you're responsive?
And 6 months if it takes a little bit.
So be ready. I'm sorry, man, but you've got time. Okay. All right. Okay. All right. All right. Please. Mr. Foster, I'm now putting an ankle monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. You pick up a third case, I'm going to light you up. Do you understand? You become a danger to my community. I only have one place for you. I will protect my community at all costs. Do you understand? If I find that you have a weapon, likewise, I will revoke this bond and I'm going to go nuts.
It was at 8:50, Your Honor, PM, so.
No alcohol, no dope. I don't want you out in the middle of the night, and no contact with your co-defendant in that case. Do you understand?
Say my co-defendant.
Correct. No contact. Do you understand? The person you were arrested with in the felony case. Take a seat for me. We'll be here with you momentarily. No smoking weed.
Yes, sir.
Do not have anything that has weed in it. Do not hang out with people who are smoking. I don't care if you come in here and say, well, I was in a car and everybody else was smoking and that's how excuses go in this here and they go out that here.
Yes, sir.
Do you understand?
Yes, sir.
Make yourself into something. Knowledge is power.
Yes, sir.
All right. Good luck. See you 45 days. I'm going to test you again. Yeah. Dismiss Vessel.
So these were her local cases we're resolving with time served, and she has a fugitive case.
You represent her on the fugitive?
Yes, Judge, and so she has a waiver on file, and so we're just trying to get the 14 days started.
All right. Good morning, Ms. Vessel. You're charged with failure to identify oneself as a fugitive from justice, so it elevates it to Class A, so you're facing up to a year in jail and a $4,000 fine. You guys have worked out an agreement. They're offering you 19 days credit for the 19 that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, give up the right to appeal. Once you plead guilty, you cannot change this. What was the mischief? Window, car, tire.
It looks like a windshield and a car radio.
So how do you plead to this offense? Guilty or not guilty? Well, if you're not guilty, then we set you for trial. Did you actually mischief?
I plead guilty, sir.
No. This isn't a game, Ms. Vessel. If you're guilty, then you plead. If you're not guilty, then don't plead guilty. If you didn't break anything, then...
I plead guilty, sir.
Did you actually break something?
I plead guilty, sir. It's been so long, I don't even remember what happened. Honestly, it's been 3 years ago. I don't remember what happened.
Something's wrong.
It's from it's an offense dated January of 2022, Judge.
Oh, right. That's funny.
It's a bond forfeiture, Judge. Or actually, it was just as a 2B and 2B status.
The argument started between her and the complaining witness while she was taking the defendant to a bus stop. During this argument, the defendant began to kick the vehicle radio with her left foot, causing it to break.
Yes, sir.
That's what this case is about.
Yes, sir.
Was it worth it?
Sir, no, sir, it was not.
I would say that probably 99% of the people who are in jail now, because no self-control. They get upset, they wig out, and they just unleash without thinking of consequence. That's why we have jails. If you get upset, you calm, cool, collective, and I bet you, had you just walked away and just, you know what? You probably would have made that person so mad because you act calm, cool, collective, and just, that's it. Be the better person. Just walk away. Because now you've been in jail here for 19 days, another 2 weeks now because you got this fugitive case over there. Self-control. So how do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will follow the agreement. As part, they're going to dismiss that new case, right? The failure to ID?
The fugitive case.
All right.
It's a failure to ID, fugitive from justice.
That's all. Self-control. All right. Good luck.
Thank you, Judge.
Thank you, Jim. Good morning, Mr. Williams. Mr. Williams, you stand charged with the offense of terroristic threat of a family or a household member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I have a lawyer here that's representing you now. She's on Zoom. It's Ms. Gooch, so that you know you're not alone.
Yes, Judge. On December 29, 2024, the officer was dispatched to a disturbance involving a weapon at an apartment in Harris County, Texas. The officer made contact with the complainant. The complainant stated she and the defendant are in a dating relationship. She left the club with a witness, and she received a call from the defendant asking where she was at. The defendant was upset because she was not at the apartment when he was there.
So hold on. Don't look at his computer.
And the defendant was texting her that she better not be at the apartment, as that would be her best bet after he walked to the club and the complainant wasn't there. The complainant stated when she returned to the apartment, she observed the defendant walking towards the motor vehicle she was in with a black metal object in his hand, banging on the window of the motor vehicle. The defendant told the complainant to get out of the motor vehicle or he was going to drag her ass out. The complainant felt threatened and called the officers. The defendant sent text messages to the complainant reading, "It's cool because whenever I catch you, I promise you on my life, bitch, I'm gonna show you. You can think I'm bullshitting. Let that bum ass have you, y'all made for each other on my mama. So I'm telling you to stay where you at for real. But whenever you come here, bitch, you better have backup because I'm gonna go drag you, bitch."
Lori, I brought him out, and the reason I did was because my concern is that your bond is now set at $10,000. There's got to be a reason because nearly everybody now gets either a PR bond or a general order bond, and I'm curious and I wonder why they didn't give you a bond. So I'm going to read now what the magistrate said. I don't know what these acronyms are. It says FA:LLHC, race, caretaker for disabled mom, independent contractor, receives government benefits, indigent, defendant allegedly had a black metal object in his hand and threatened to drag complaining witness girlfriend out of the vehicle before punching the car window. Defendant also allegedly sent text messages to witness stating that he would punch complaining witness, quote unquote, dead in her shit on his mama, unquote. Criminal history, interference with the request for emergency assistance, 8/24, same complaining witness. Dismissed, assault of a family member, impeding breath, 2021, same complaining witness, and other criminal history. I find by clear and convincing evidence that there are no non-financial conditions of bond that will suffice to reasonably assure public safety for the following reasons. This defendant's numerous prior incarcerations and history of violence have not deterred this defendant from engaging in criminal conduct involving the same complaining witness. Bond conditions are not likely to be a deterrent, so a high bond is necessary in this case. This is why you were not given a PR bond. And don't say anything. I want you to talk to your lawyer before you say anything. I've got a bunch of DAs here. Everything you say, they're going to sit there and they're going to type it to use and prove guilt. So it's just best not to. My only problem, and I want you to understand that my only concern, Mr. Williams, is public safety. That's the only thing I care about in this life, right?
We're not allowed to have no dealings with each other. I already got my stuff packed.
Stop. You don't have to say anything. You don't have to justify. I just want you to know that
I understand.
I don't know if you're going to bond out, but if you do, I'm going to put a monitor on your ankle prior to your release so I know where you are, and I don't want you to have any contact with this person.
So there's no way I can get a PR bond.
There's a protective order that's been issued in this case. I would get to know it because if you violate this protective order, the state can file a violation of a protective order, and that is the capital murder of misdemeanors. You pick up a VPO, we are really deep, you know what. So what I'm going to do now is I'm going to have you put back. I'm going to have Lori reach out to you so you guys can talk, and then she can come back and tell me how we move forward. Okay? And then we'll go from there. Please. James.
John, may we approach?
Yeah.
Judge, I'm approaching with Mr. Stradley, who's.
Yes. The extraordinary Mr. Stradley.
Thank you, Judge. Yes, Judge. Who's
on the bed?
Who's actually representing the parents of Nicholas Lane. So his competency report came back that he's not competent, but he's not here. He bonded out the 23rd.
I bonded him out, Judge, for the parents on the 23rd.
He's supposed to be here.
He is, and I told him when I went to see him to say, hey, I'm about to bond you out. You realize you have court on the 31st. And he said that he knew, so.
He's not here.
He's not here, so I get it.
What I can do is I can set it for, today's Tuesday. I can set up for bond forfeiture for later this week. He has to be here.
Friday, Judge?
You do Thursday?
I'll be here.
I'm going to set up for bond forfeiture for Thursday. If I can't get him in here, I'm going to end up revoking his bond.
It's fine, Judge. Do you mind?
But did you sign for the, you know?
Yes, I posted the bond for the parents. We get it. I mean, it is what it is. You know, if there needs to be an open warrant for him in order to get him in a safe place,
okay,
then so be it.
What we could do is, my only fear, what you said about your rehab facility is that it's not a lockdown facility. So basically he can get up and go. So my trepidation with doing what you want to do is that he can get up and go.
If be able to do a Menninger thing, and I think that is more of a lockdown than.
Then I'm all ears. But otherwise, what I would prefer to have done is TRAS, whatever they say. It may be DDRP, maybe SAFE-P, SATA. We can put him in there, and he can't get out. He's stuck until he completes the program. But the only issue is that he's got to be competent. So what we would do is get him in, stabilize him, have him however, try to get him stabilized. Once he's stabilized and good to go, then we put him in.
I think
that's two ways.
On behalf of his parents, they just want him to be safe, you know, and they suspect that he's living hard right now. And so, you know, I understand that the best case scenario is probably a warrant. And the 5,000 is not the ultimate consideration here, Judge. So
I understand.
So,
okay, so we'll set up for bond forfeiture for Thursday. If he doesn't appear here Thursday, we issue the warrant and we'll go from there.
Thank you, Judge. And I'll zoom in if it's okay with you.
Absolutely. That's why we have it.
Thank you, Judge.
Okay, thank you, James. Townsend.
I need to clear.
Yes, Judge.
Probation, but it was reduced, so they reduced it by abandoning the previous DWI and abandoning the SF. No, they abandoned both the answers. So when you plead true to the high base,
We can't do it. We can't do the plea true. We have to do just a straight. We can't do it true because they didn't plead it as a 0.15 or above.
No, it was except I was saying if you
No,
wanted
no,
to
no.
keep it.
No, I mean, I can't
change it from Class B back to Class A.
just leave it as this and take off the enhancement. I'll take off those enhancements.
So by leaving him out for 35.
No, I can't. Just do 3,000.
Mr. Dugan?
Yeah.
Okay.
Is Eric still here or no? I gotta call him. Okay, so we'll do the 3,000 instead of the 4,500.
Okay.
And then what? Okay.
Hello again, Judge. I'm approaching on a case coming out of Court 6, Judge.
Sure.
If I may be heard on this.
Go for it. I need a cause number.
Yes, Judge. Cause number 2530393.
I'm green.
Yes, Judge. I'm approaching on bond conditions, Judge. On my client's first amended order for pretrial bond conditions, it's alleged that facts give rise to probable cause suggesting that alcohol was a factor in this offense. The state has no objection to this. There is nothing in the DIMS or the offense report that indicates any alcohol or anything of that sort.
Will you read the DIMS? Read it.
Yes, Judge. Do you want the
Was any mention of alcohol or drugs mentioned in this? Who did that? The magistrate?
Judge, I believe it was a visiting judge in Court 6.
Can I get the call number? 2530393. 2530393.
Is that? I think it's Sherman. Judge Ross. It looks like Judge Ross's signature.
Yeah, that's not a magistrate
He
signature.
just wants to the bond condition for no.
So what do you want?
I'd like for that condition to be lifted, Judge.
Which one?
The defendant must not use, possess, or consume alcohol. This includes any food, mouthwash, or over-the-counter medication containing alcohol, Judge.
How old is she?
She is 20 years old.
No, she can't drink anyways.
Judge,
No.
it's not necessarily, well, one, she is 20, I believe she turns 21 in, I believe, June or July. She lives with her grandmother, and my understanding of Texas law is that she may drink an alcoholic beverage with her guardian present, which is her grandmother. Second, these bond conditions include food, mouthwash. Judge, I want my client to be able to use mouthwash without being in fear of violating her bond. And three, there's no legs for this to even stand on. There's no probable cause that substantiates these bond conditions. And it doesn't ensure that she will appear in court. It's just overly burdensome. And again, there's no probable cause to even substantiate.
Okay, but no.
Yes, sir.
Leave it on. She's 20. I don't want her to drink. There's plenty of mouthwash out there that doesn't have alcohol in it that she should be able to use.
Yes, sir.
So it's not too onerous. It's not overly burdensome. It's, just she's 20. When she turns 21, come back and we can talk.
Yes, sir. Thank you, Judge.
Of course.
Happy New Year.
You too. Mr. Brooker.
Hey, don't stand there, Bruce.
Great to see you, man.
Same here.
How are you? Yeah, you?
I had a good time too. I'm here on Evan Nelson, Judge, and essentially just to ask you for more time. The state made an offer that we like. We are willing to accept it. One of the issues is that property is taken as a result of firearms, and the state at this point is requesting a forfeiture of that firearm, pending proof of its lineage and where it came from and all of that. He's waiting for an affidavit from the person he purchased the weapon
Well, but
from.
that shouldn't hold up the case, though.
I understand, and that's why I'm just asking for some additional time to maybe a week or two, just for him to get the affidavit. I came before you last setting, asking for the same thing. He was unable to get it over the holidays. He's spoken to the person, communicated with him. It's just an affidavit that will show to the state. They'll decide yes or no, and we'll do the plea that day.
It's an affidavit to get the gun back or to get the case
demonstrate
dismissed?
Ownership in the lineage. It's a weapon that was owned by an individual that was in the military, has some historical and family value. So my client, he's willing to take the plea, but he doesn't want to lose the weapon because it was gifted to him. It has like all types of Texas.
It's not going to impact because they don't file either destructive orders or orders of this nature for years.
Part of the plea bargain agreement was forfeiture of the weapon. And that was the issue that.
I don't have to agree to that.
It's the policy I was told that we were supposed to do for UCWs. But if you would like,
I'll hold on. I won't rule on that. I won't do that. Because there are plenty of people that they do want their guns back. Believe it or not, there's some guns from like 1862, 1752, 1600s, man. Watch Pawn.
Right.
My favorite shows is Pawn. Palms, dude, freaking amazing. You know? God, I've learned so much about guns and I hate guns. But yeah, I'm with you.
Okay. So you would be opposed to granting that portion of the plea bargain and allow us to do the plea?
Let's do the plea.
Okay.
Let's get it done. And then I'm not going to rule on the forfeiture of the weapon. I won't do anything of this. And then just that way, you take your time.
Okay.
There's no rush. But at some point, they're going to file a motion to either destroy. And if he's not in time to get it, then the gun goes bye-bye.
And normally that happens at the end of the plea. This is, I think, our concern. If they agree to them being able to recover his weapon, then we wouldn't have to be concerned about what would happen later.
Well, I'm the one that grants it regardless. So even if they're opposed, I can still grant it regardless.
Sure.
You know, and I've done that. I did that, 2 months ago. They were opposed, but I still granted it because they provided an affidavit.
Understood.
Yeah. Okay.
Thank you.
For sure. John. Hey.
As I'm approaching you on Mr. Serrato with a C, C-E-R.
Okay.
Judge, we just got some updated information from the state. They were finally able to get the rip done. The chief is okay with the PTI, but she needs some litigation. This is all just came this morning because they were able to get, they were able to get a hold of that. So if you just give me a short time, I can get all that.
It's 190. I'll give you a couple weeks. He's got to have it all.
No, I got you, Judge. I mean, we would have, it's just.
Okay. Don't worry about it. I'll give you a couple weeks, but if he doesn't have it done, then.
No worries. I mean, that's all I need. It should be okay.
What else?
Okay. That's it.
That it then? Okay.
Well, we're waiting for a hunter, but just for the.
Hey, don't worry. It looks like it may have been a malfunctioning device.
Happy New Year, y'all. Okay.
So, come up.
Was it an alcohol thing or?
No. So what he has a GPS monitor, and it looks like they lost cell service for a couple days, and then I think he goes back to pretrial, and they're able to see that there may have been an issue with the battery.
The charger, I guess the
charger.
connection port, the only issue with those violations before is that we couldn't get in contact with him a few times to have a report earlier because these were started on the 18th and we tried contacting him a few times.
Okay, so you got to make sure that they have the correct number, because if they can't get a hold of you, they send me these bond violation reports, and then that's why you're here now, right? So just maintain good contact with them. Make sure that the device is charged. If you ever have any issue, go back to them. They'll give you a new one. They'll fix it so that there are no issues. I'm going to give you the benefit of the doubt now. Just please make sure that everything is on the up and up from now on. Okay? Your last name is George, right? Okay, the case is only 104 days old, so we'll just give you a normal reset, Jillian, huh?
Okay, sounds good.
What say you?
Williams?
Yeah.
I wonder if he had a date.
The date previously was, 114. Do you want to keep 114 or do you want to do it out further, Jillian?
We can keep 114.
Okay. All right. We'll give you just another reset and then it'll be waived. I'll waive your appearance because it's not an old case, but just stay in touch with Jillian. Okay? All right. Please.
Thank you, Judge.
All right. Thanks, Jillian. What are y'all doing for New Year's? Anything good?
Just a dinner. What about you?
No. Just kind of hanging out, same thing.
It's just not worth the risk.
Yeah. They're out in force. So if you go out there, you even have one, you get pulled over.
Yeah.
Yeah.
I just like the number of crashes. I can't even imagine. Even if you're being good driving.
It's sad, isn't it?
It's hard.
You know, I was just now in court 3, and there was a case where it's a DWI, second, hits a horse with a kid on it, horse dies, kid in hospital.
What?
Yeah.
Shit.
Hey, Judge,
I don't remember where, but
It's up here.
you know what I mean?
Oh, how nice. We got multiple.
Stop. No.
Just want
to stay. So that's how old you are.
That's a good one.
Do you, this one's finished or can we?
I'm almost done. I'm almost done.
What are all y'all's names?
That's
He can talk. I think he gets shy.
Yeah.
Judge, what was that thing? He had 5 kids.
No. If I had more money, I'd have more kids. Okay, we are on the record in cause number 247-3585. Today is January 2nd, Thursday, January 2nd. It's approximately 10:14 a.m. Guys, if you would please announce yourselves for purposes of the record.
The state, Kelsey Siegler.
For defense, Garrett Gibbons and Brett Landrial, representing Ernesto Gutierrez.
Mr. Ernesto Gutierrez stands charged with the offense of making a firearm accessible to a child. He's facing up to a year in jail and or a $4,000 fine. We were here last time on December 19th, state having offered 270 days in jail, and defense and state couldn't come up to an agreement, and so state waived. Defense has come to us for punishment, asking the court to punish Mr. Gutierrez. With regard to this case, we have done the agreement. He has pled guilty to the offense. So now we are set for punishment in this case today. One of the things that I would like to know is how this has changed you, Mr. Gutierrez. What have you done differently?
Ha cambiado totalmente mi vida.
My life has changed completely.
My trabajo, mi vida social.
My work, my social life, everything.
What have you done differently? So that we know that you appreciate the gravity of what has happened. What have you done differently? Losing a child is probably one of the worst things that can happen in life. You know, when you have a child, you are tasked with loving, protecting, raising, making that person the best they can be. That is the duty of a father. Here, you allegedly left a gun on a bed. The child found the gun, or one of the children found the gun, and did the unthinkable. What have you done that is, so I know that you appreciate the gravity of what has happened? Did you go to therapy? Did you see a psychologist? What have you done?
Mi familia y yo hemos estado asistiendo a terapias.
My family and I have been attending therapy.
Trabajamos 3 meses con trabajadores, estuvieron visitando trabajadores sociales.
We, for 3 months, were being visited by social workers.
So CPS got involved, I guess? What happened with that? Anything?
Pues durante ese tiempo
ellos estuvieron asistiendo a mis niños,
Well, during that time,
a mi
they were
esposa y
helping
a
my
mí.
children, my wife and myself,
ah, para ayudarnos con la situación.
to help us with that
So
situation.
you had a CPS plan in place then? Is CPS still involved in your life now? How long are they expected to be in your lives?
Ellos estuvieron casi 4 meses con nosotros.
They were with us for almost 4 months,
Y aún tenemos contacto con la psicóloga.
and we still are in touch with the psychologist that helped us.
Ah, Personalmente he tomado todas las medidas para que mis hijos no estén solos
Personally,
en
I
la
have
casa
taken measures to make sure that my children are not alone in the house.
todo el tiempo. Mi esposa ha estado con ellos y
My
ahorita mi
wife
padre,
has been with them the entire time, and even right now,
mientras yo trabajo para sostener a mi.
while I work to support them.
ah, Ha sido bien difícil.
It's been very difficult.
How many children do you have now?
Three.
Did you just have another child?
Your Honor, they're all here today.
Yes.
What do you want?
Your Honor, may I address the court? Okay. Judge, you know, this is a very good man. I have hundreds of clients. As you know, being a judge, not all of them are good. Oftentimes, there's a lot of bad people in this world that, you know, over the course of the past few months, I've gotten the honor, the privilege of getting to know this man, getting to know his family, sitting here in your honorable court today. These are good people from Venezuela. And Judge, in my first 2 or 3 years of practice, I did catastrophic injuries, wrongful death, personal injury work. I saw oftentimes a horrible accident like this would happen. Husband and wife would divorce, families would be, you know, left in shambles. This is a man that the family really needs. He's the sole provider of the house. He's a good father. He's a good husband. When the wife and the kids came to my office last week, when we talked about this case and I was preparing them for today, the wife couldn't even look me in the eyes. The children had a panic attack. They're scared to death that they're going to lose their father, their husband, everything to them. He's the glue that holds the family together. And he's scared to death of the great power, Judge, that you have and that this court has. And I told you this last time during the guilty plea, and I'll tell the court this now. Judge, it really doesn't matter if you give this guy,
sure,
but if you give him, you know, deferred or you give him a death penalty, you know, just I know I'm being, you know, I know I'm embellishing. It doesn't matter if the court gives him 100 years in prison. This man will never forgive himself. He hates himself.
What do you want?
Judge, I want the best case scenario. I don't know if the court can give a diversion or intervention. That would be great. If not, at the very worst, deferred adjudication, Judge, because I want to keep this man out of prison because his family needs him. I brought them today. They will also tell His Honor how much they need him, and that without him going to prison, prison is not, or excuse me, jail is not the place for this gentleman. Because then those kids will grow up without a dad. All financial contributions will be over with, and this whole family will be destroyed. And then most likely, you know, there's a very strong possibility that he will be deported. We've already, you know, admonished him ourselves about this, but Ernesto, I want you to look at the judge. Are you sorry? You acknowledge the fact that you have messed up? Do you take responsibility for this?
Totally.
Do you hate yourself?
Yes.
And are you begging the judge for mercy?
al juez de misericordia. Yes.
Do you understand that he has the power to throw you in jail and throw away the key and you sit there and rot away?
Yes.
Tell him why you deserve mercy.
Porque usted merece misericordia.
Yo no quiero que mi familia se quede solo.
I don't want my family to be left
Yo soy
alone.
el soporte.
I am the sole support of my family.
Is there anything else you want to tell the judge?
Algo más que le quiero decir al juez.
Pido piedad. Solo. Pido piedad que tenga
Just asking for mercy. Be merciful on me.
no solamente esta situación va a afectar a mí, sino a mis hijos también.
This situation is not just going to affect me, but also my children as well.
Your Honor, would you like to hear from the wife
Quisiera oír de
or the kids or the father or
I
friends?
think that they've probably been punished enough for this, really.
Thank you,
Do you want to
Judge.
add anything?
Just that you've seen more cases than any of us, and I know that you'll do the right thing, so we defer to you. And I understand when we first met to show signs of remorse and things that he's done after that, and it appears he has done those things.
You know, I will tell you this, that if this were a case where there had been the death of someone else's child, then I think that that would absolutely 100% unequivocally be jail and a really long and healthy jail sentence. But in this case, I think that when you do something of this nature where you end up with the death of your own child, I think that that's about as bad as it gets. You know, I really feel for you. You know, it's not going to be an easy thing to, you know. I don't think
Yo no creo
something with a dismissal is appropriate in this case, because I think the world needs to be on notice of what has happened, you know. And, you know, I shudder to think that anytime you look at a picture, anytime you do an activity, it's gonna bring up a memory, you know. I have a problem dealing with it myself. Just think before you act. Think before you speak. Because kids are crafty. I've seen this all too much. And we had a case here where a kid climbed up, you know, a bookcase that was 15 feet high, took a gun and killed. Just, if you have weapons, you don't need to have them accessible or even near a child. Sentence you to 1 year in jail. I'm going to probate it for 2. I'm not going to put you in jail now because I think that I hope that this is punishment enough. I am going to keep tabs on you so I know that you're doing well. I'm not going to let you go for 2 years. And I want him to do thinking for a change.
Yes.
I don't want you to be in possession of weapons. I don't want you to consume alcohol. I don't want you to consume illegal drugs. You mess up, I am going to put you in jail. If you pick up a new case, I will put you in jail. I think that if I were to put you in jail now, what it would probably end up doing is punishing your family more than you. And there are a lot of people that depend on you. Make the right decision. It's not hard. And I mean, leaving a gun on a bed. Anything else you think?
Please.
I don't care about the money. Money's the least of my concern. That's a good idea. although he's probably having to do it with CPS regardless. So let's see if he's doing it with CPS. And then, just the idea is that you leave here better than you came. That's what makes us happy. And that's what we strive for every single person that comes through our court. We want you to leave better than you came. I feel your pain. If I could hug you, I would, Mr. Gutierrez, but it's tragic. It sucks. All right, guys.
Your Honor, may I address the court?
Sure.
We just want to thank you so much for the compassion that you've shown, Mr. Gutierrez, and it's just an honor to be before you. We really appreciate you hearing us out, and will you tell Judge thank you?
Thank you.
Judge, you've saved his life. So I hope you know that. May we be excused?
Got it.
Thank you, Judge.
On December 25th, 2024, officer was dispatched to an apartment in response to a disturbance. The officer spoke to apartment security officers who stated that the defendant was sitting in the back of their security vehicle and that the complainant was inside the apartment. The complainant stated that his wife had a Christmas party and the defendant attended, but that he had never met the defendant before. The complainant had gone outside to smoke, and when he returned, he saw the defendant arguing with his wife, and the complainant intervened, and the defendant swung at him with a closed fist. The complainant swung back, but the defendant struck the complainant several times in the face, causing pain. The officers observed that the complainant had a bloody lip and a hand, and the defendant stated that the complainant swung at him first, but did not hit him. Multiple witnesses confirmed the complainant's account. And for the failure to stop and give information, the officer was dispatched to a crash at an intersection in Harris County, Texas, and the complainant advised that he was stopped at a red light. When the light turned green, he entered the intersection. At this point, the defendant ran the red light and struck the complainant's car. Both parties exited their vehicles, and the defendant's vehicle was inoperable due to the damage, and the defendant ran away on foot towards a Home Depot. The complainant clearly saw the defendant's face, and the defendant's phone was inside his vehicle, and his GPS was open to his residence, which was less than half a mile away. The officers found multiple beer cans and a liquor bottle inside the defendant's vehicle, and the complainant estimated he sustained damage of over $200.
Was he on bond for the FSGI and pick up the assault?
Judge, I do have it here that he had conditions from the magistrate from the 18th on the FSGI.
So yes.
It was a surety bond. Due to the offense, Judge is also a PPL on the FSGI.
Run his license for me, please.
It's not eligible, Your Honor.
Mr. Castillo, let me make you something abundantly clear to you, that I will not stand for this in my county. And look at me. I'm going to do everything in my power to protect my county at all costs. Do you understand?
Yes, Your Honor.
If I find that you act like a fool in the free world, I will take the free world away from you in a heartbeat. I'm ordering you now, and I'm going to have you sign an affidavit with me that you're not allowed to drive. I don't care what is going on in your life. If I find that you drive, I will have a contempt hearing. I can have a contempt hearing, and I can hold you in contempt and slap you with 180 days every single time you get to a car and drive. Do you understand? If you drove here, you are not allowed to drive home. Do you understand? On one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. You consume alcohol, you smoke any dope, I'm going to put you in jail. Right now, I'm going to send you for a drug and alcohol test because I want to know what, if anything, is in your system. Like I said, you're also on probation for a felony DWI. It's very possible they file another motion to revoke the probation. I'm going to have you come up here, swear test that you're not going to drive. I'm going to have you sign a recent Victorian. You're going to get with Felicia for your bond conditions, and I'm going to have you come back after your drug test. Do you understand?
Yes, Your Honor.
You're not to use, consume marijuana, anything, and I'm going to test you regularly so I know that you're not using. Do you understand?
Yes, Your Honor.
Come on. Connor, Mr. Connor, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. I'm showing that this case is 361 days old. Mr. Connor, your case is 361 days old, and I'm giving you 2 weeks to have a lawyer, and when you come back, we're going to set your case for trial. Do you understand? If you ever take off on me again, I'm going to triple, if not maybe quadruple your bond. No more PR bonds for you. Do you understand? Okay. No alcohol, no drugs. I'm ready to set this case for trial. You've taken off on us repeatedly. Your case is 361 days old. We set cases for trial at 180 days. Have a lawyer when you come back, because the next setting, I'm telling you what's going to happen. Do you understand? You see if he has a Texas driver license. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. I don't care if you have a baby that's born and you got to rush to the hospital. If you don't have a license and liability insurance, do not drive. Do you understand?
Yes, Judge.
So, Felicia, normal bond conditions, please, and then Vic, 2 weeks. And next plea is trial or plea. Next setting. Come on. Good morning, Mr. Curtis. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Officers were dispatched to a Holiday Inn in Harris County, Texas, in response to a disturbance. The caller reported that 2 white males left the property, one in an F-150 and one in a Mitsubishi. When the officer arrived, he observed the Mitsubishi, which matched the description given in the parking lot, headed towards a nearby road. The officer initiated a traffic stop and made contact with the driver, the defendant. The officer asked the defendant if he was involved in a physical disturbance, and the defendant stated yes, that him and another individual got into a physical fight, and that he got into his car to separate himself and calm down. The defendant stated he was heading towards a gas station when he was stopped by the officer. While speaking to the defendant, the officer observed an odor of alcoholic beverage, glossy eyes, and slurred speech. The defendant admitted to drinking 2 beers, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 0 out of 8, one leg stand 0 out of 4. The DIC was read and the defendant consented to breath. The results were .103 and .113.
And the stop was for what?
They had a call about a disturbance, and the vehicle he was in matched the description given by the caller about individuals involved in that disturbance, and they pulled the vehicle over to inquire about that disturbance.
How do we know it has anything to do with him?
They provided.
What's going on? What's the disturbance?
What we have is that in regard to that disturbance, they were given a specific description of the vehicle, and he was asked about it, and he admitted to being involved in that disturbance when the officer encountered the vehicle.
I'm going to find probable cause for now, Mr. Curtis. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Can you run his license, please? See if he has a valid license. What do you do for a living, sir?
I'm a contractor. I'm trying to actually start my own business.
Do you have an income right now?
Yes, sir.
What kind of income do you make a month?
It just really depends. Right now, work's slow, so I've been raking leaves, trying to get anything I can to make the bills. I have 3 kids, my own house, and I'm a pregnant wife, so I'm trying to just provide.
I'm going to apply for an appointed lawyer.
Yes, sir.
Okay. And give him an application. I'm going to give you an application. I'm going to have you talk to someone today. I'm going to have you sign a reset with Victoria.
He's eligible, Your Honor.
Don't drive unless you have insurance as well, car insurance. I'm making it a condition of your bond. Don't consume alcohol. Don't consume illegal drugs, and you'll be fine with us.
Sure.
Don't be a danger to my public. All right, come on. You Mary De Leon? Ms. De Leon, you were charged with failure to stop and give information. Yes. Don't say anything. All I'm telling you is what you're charged with. We have to do probable cause. I want to know what happened with the case to see whether we go forward or not. You have the right to remain silent. Anything you say can or will be used against you. Do you understand what's going on? Okay.
Yes, Judge. The officer was dispatched to a crash in Harris County, Texas, and upon arrival, the defendant was blocked in a parking spot by the complainant. The complainant told the officer that she was driving when the defendant attempted to pass her and struck her vehicle. The defendant initially stopped, but when the complainant approached her, the defendant drove away without providing information. The defendant could not drive far due to traffic and turned into a nearby parking lot. The complainant followed and honked her horn at the defendant, trying to get her to stop. The defendant refused and nearly hit another vehicle while trying to get away from the complainant. The officer observed multiple other places that the defendant could have stopped to exchange information before the location. The complainant approximated damages at $2,000.
Okay. Mr. Alone, I'm going to find that there's probable cause to go forward with the case. Do you see if she has a valid Texas driver's license, please?
It's always void on her.
Do not drive unless you have car insurance, ma'am. I'm making that a condition of your bond. Do you understand?
I do have insurance.
Okay. What do you do for a living, ma'am?
I'm not working right now.
Would you like a lawyer then?
Yeah, of course.
Okay. Let's see, bad. I need you to fill out an application for me, and then I'll see whether you qualify. Assuming you do, we'll provide you a lawyer today. Okay, ma'am?
Sorry.
Please. You Corey Glenn?
Sorry.
Mr. Glenn, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. The officer was dispatched to a minor crash on metro tracks, and when the officer arrived, they observed the defendant stumbling, yelling at other officers, making unclear statements, and acting incoherently. The officers believe the defendant may have been intoxicated due to bloodshot, glassy eyes and slurred speech, and the defendant was initially detained for DWI investigation, however, was transported to the hospital due to not being able to stand on his own. During a vehicle inventory, the officers located a firearm on the left side of the driver's seat, unholstered.
Where was it again?
It was on the left side of the driver's seat, unholstered.
So what happened with the DWI? Are they going to file it?
DWI was not filed, Your Honor.
Mr. Glenn, I'm going to find that there's probable cause to go forward with your case. Can you run this license, please?
Yes, Judge.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand?
Your Honor is not eligible.
You will be signing an affidavit with me today promising me you're not going to drive. Mr. Glenn, I don't care what's going on in your life. I don't care if there's a burning building and you have to save 50 kids. If you don't have a license and car insurance, do not drive. Go to DPS, find out what you need to do, get your license, get it back, and I'll take this off. But until this point, if I find that you drive, it's really not going to go well for you. Do you understand? We are going to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I'll have you meet with Fleischer for your bond conditions, and then you'll be headed out there. When you come back, please have a lawyer, sir. Please. All right, come on. Good morning, Mr. Martinez. Sir, you were charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officers were dispatched to a disturbance at a residence in Harris County, Texas. The officers made contact with the defendant and a witness, the defendant's boyfriend. The officers observed the defendant to be highly intoxicated, and the officer tried to ask the witness what happened, and the defendant continuously interrupted and would not allow the witness to speak to the officer. The officer then temporarily detained the defendant, and the witness stated that he and the defendant were eating dinner with the witness's friend, the complainant. The defendant began to get hostile towards the witness and the complainant during dinner, and the complainant decided to leave and go home. The complainant lives 2 streets over from the witness. After the complainant left, the defendant took the witness's keys to his vehicle and stated, "I'm going to find that bitch and teach that old bitch a lesson." The witness then called the complainant to tell her what the defendant said, and the complainant was afraid and then told her neighbor about the threat in case something happened. The defendant then called the witness 5 times in 3 minutes and texted her, "Outside your house, bitch." The complainant was in fear for her life due to the defendant's statements.
So the initial threat is just like an open threat, not made to.
It was actually, it was said to the witness, but then later he texted the complainant directly stating that he was outside her house.
All right, for now, Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. You know, in life, there are people, when they consume alcohol, they turn into like very jovial, fun, You know, and then there are people who develop horns and a tail when they start drinking. Don't drink. Do you understand? I'm making it a condition of your bond that you're not to consume alcohol or illegal drugs. And if I find that you do, I'm going to put you in jail. Do you understand? No more PR bonds for you. I'm also ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand your bond conditions?
Yes, Your Honor.
How old are you, sir? Do you have an income? What do you do for a living?
I manage the inventory for PetSmart.
Okay. Do you have the ability to hire a lawyer, sir?
It depends. I mean,
What kind of money do you make a month?
it fluctuates. It's not really like, I don't know. My checks go up and down depending on how many hours we work.
I need to know exactly how much you make if you want to apply for a court-appointed lawyer. So I can send you home with an application if you'd like. You can fill one out here, but I need to know exactly how much money you want to make. Otherwise, you'll be required to go hire a lawyer. So look, what do you want to try to apply for a lawyer, or do you want to go out and hire a lawyer?
I can apply for one. I don't know.
Okay, I need you to be honest on the application. This is an affidavit that you're filling out. So be honest. I need to know everything about you. How much money you have in the bank, what kind of car you drive, stocks.
I don't drive.
Just, what I'm telling you is I need to know everything about you. How much money you have in the bank, stocks, bonds, mutual funds, IRAs, information of this nature, and then I'll see whether you qualify, okay? Stephen will give you an application. They'll have you sign a reset. You're going to meet with Fleischer, your bond conditions, and then we'll take a look at the application. Good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 7th, 2024, officer conducted a traffic stop on the defendant's vehicle. After observing it failed to maintain a single lane, swerved between multiple lanes and almost struck the officer's vehicle. The defendant was the driver and sole occupant of the motor vehicle, and upon contact with the defendant, the officer observed a strong odor of an alcoholic beverage, slurred speech, bloodshot red eyes. The defendant appeared confused, and the defendant had trouble standing up straight and was swaying while standing. Standard filter sobriety were performed. HGN 5 out of 6. Walk and turn 6 out of 8, one leg stand 4 out of 4. The GIC was read, but the defendant refused, and a blood search warrant was drawn and executed.
Ready to be honest? Okay, if you
No,
go,
Your Honor.
NCIC license.
Eligible.
Okay. Mr. Chaconis, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, into jail you will go. Tell me, are you in this country with permission or no?
Excuse me?
You were in ICE custody, correct?
Correct.
You bonded out of that ICE custody. Do you have a Texas driver license?
Not anymore.
How do you, that's my question, Alex, because
I'll rerun it.
how,
I don't know. Yeah.
if you don't have a license, don't drive. I am making it a condition of your bond. Unless you have a Texas driver license and liability insurance, do not drive. Do you understand?
Yes, sir.
It's still showing eligible on our end.
I don't know. So, it's your responsibility to go to DPS and find out if it's still valid or not. If it's not, don't drive.
Okay.
Also, don't consume alcohol or illegal drugs. You've got a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with counsel. If they come back, if they tell me they can't get a hold of you because you've flown the coop, I will issue a warrant for your arrest. If you pick up a new case, likewise, I'm going to issue a warrant for your arrest. Just be good. That's it. Do you have any questions?
Yes, sir.
Okay. I'll have you sign a resale with Victoria. We'll have you get with Fleischer your bond conditions, and then you're free to go.
Thank you, Your Honor.
Thanks, guys. Don't use marijuana. Do you understand? The test came back. Did it say positive for marijuana?
Yes.
I'm going to test you 45 days. If I find that you still test positive, I'm going to put you in jail. Do you understand? Because that tells me that you've continued to smoke. I'm not going to let you do it while you're on bond in this court. Do you understand? Don't pick up a new case. There are co-defendants in this case, right?
Yes.
Don't have contact with the co-defendants as well. You understand? It's not easy to make everybody happy here. I'm not asking much from you. Do you understand? Okay, all right. Yes, ma'am.
Judge, Happy New Year.
Hey, bud. Who you got?
I have Derek Castillo this morning. So this is a DWI judge where there was a Brady disclosure disclosing several suspects. I had subpoenaed the internal affairs records as well as his personnel file, including the G file. There's stuff in there about investigations.
Have you gotten everything?
I haven't gotten anything. The sheriff's office hasn't responded to me. At the last setting, you had asked the state to sheriff's office records. Hadn't seen a subpoena issued.
They've received the subpoena. I talked to defense about this morning. So HCO Legal has received the subpoena that he sent. They've sent it to their, I think, paralegal, or I'm not sure the staff member, but someone is handling it. I checked up again with our disclosure database, who she said she double checked. Those are all the documents that we have. So honestly, Judge, like we had to go through GenLit for this. I'm not even entirely sure how to proceed. They have received your subpoena though.
So,
right.
Are you telling me that they've given him everything that they have?
They've given me everything that they've said that they have. But if there's an ongoing investigation, I don't know, because that's a different department. This is all like us working through the sheriff's office.
There's someone being investigated?
I'm not sure, Judge. I uploaded the documents this morning. There's the same documents I had already uploaded.
Colin, are you looking for something specific, or is it just like a general?
No, I'm not going on a fishing expedition, Judge. I've got Brady.
Well, because they're saying that they've given you everything that they have.
Okay.
That's why I'm asking you, is there something specific that you're looking for or expecting to get for us to push harder?
The personnel file, which I don't believe I've received that yet. That would include the G file under the Public Information Act. That file sometimes has things that they don't put in with investigations or they are a part of an investigation that they put in the G file because they've decided, oh, well, we're not going to sustain that as a complaint.
But I guess if no one has been in trouble, is there such a file that exists, you know? So that's
why in trouble. That's the thing, Judge. He's been suspended multiple times.
Okay, we need to get him down here.
Well, Judge, that officer's not in possession of this file. That's like with.
Sure. Okay. Well, then whoever is, I guess, whatever agency, we need them here to explain. You know, they've gotten the subpoena. They've not either complied or said anything.
Have they contacted you, Colin? Like, department? No. Okay.
Oh, I mean, we've reached out, but we haven't heard.
Okay. Yeah. All I was told, because Day also emailed them, and all we were told was that they've received your subpoena and it was sent to their legal. But from there, I mean, I can try to send an additional subpoena to them, like to their legal department to reach out. But it's like it's a process. I had to talk to like several people in GenLit about this. So
I've gone through this before, Judge, and that's why I do this. Is because I had a case just a few months ago where an officer was suspended. It wasn't suspended. He was fired for 30 days and then rehired. Come to find out.
Is that this one?
No, it wasn't this one, Judge, but this is why I do.
Well, let's do this. Let's set it for let's set it for Tuesday next week. Okay. Have whoever's in charge of that department, have them come here so we can figure out what's going on. You know?
I did try to call them, but just given the holiday on Tuesday.
Sure. So
I will try to call them again today, Judge.
And then let's have a hearing on this on Tuesday. You know, I don't want to have to take it further, so hopefully they'll respond. Okay?
Judge, can we actually do that on Wednesday? Would that be okay with
Sure.
you?
Yeah.
Busy day.
You went Wednesday.
Wednesday? Okay.
Yeah. Okay. All right.
All right. And we keep the appearance waived for my client. Thank you, Your Honor.
Okay. All right, Colin.
Okay, good. Thank you.
See you then.
Take care.
Hi. Is your client here? I can't. Just too many violations over and over and over. If he's not here, I'm revoking his bond. I've already given him as much leeway as I can, but we literally have revocation, or we have violation after violation after violation after violation. At some point, I have to say when. I think I've been more than accommodating. I've been more than patient. You know what I mean? Really. How many times have you let him? I don't care about his mom. Okay, how do I know that?
She's supposed to be sending me something, and I'll give it to you once I he did send me a list of concurrent medication, and one of his medications does have 20% alcohol in it. But as far as the tampering, I haven't been able to speak with Mr. K. That's for.
Yeah, I don't know, but it's too much. It's too much.
I do, if I can bring the in the hospital today, would you do?
I'll take a look whatever you give me. Okay, we'll go. Yeah. All right. You are Jesse Joe Proctor. Mr. Proctor, you're charged with terroristic threat. It's a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
Yes, Judge. On November 7th, 2024, officers were dispatched to a burglary residence in progress. Upon arrival, the defendant was found standing in front of the complainant, the defendant's ex-girlfriend, and the defendant had been sending threatening text messages to the complainant stating someone was going to die tonight and that it would be the complainant and her mother. The defendant further stated he would be taking his gun to the complainant's house, and the officer observed the text messages and confirmed the defendant sent them. The defendant also advised the officers that he sent the messages to get the complainant's attention. The complainant stated the defendant had attempted to gain entry into her home, and the complainant stated she feared for her life and would like to pursue charges.
I'm going to find that there's probable cause to go forward with your case. Now, as a condition of your bond, not to have any contact with this person. Do you understand? I'm going to do everything in my power to protect my public. If I find that you're a danger to my public, I'm just going to put you in jail and make your bond high. Do you understand? I don't care who you are. I don't care what color you are. I don't care if you're a small farm animal. You endanger my community, it's over. You're not to be in possession of any weapons and not to go within 500 feet of where she lives or where she works. Can you do me a favor? Right now, while we have him here, reach out to see if there's still been any more issues. Because if there is, I'm tempted to put a monitor on him so we know that he's not going anywhere near her. Please.
Yes, Judge, because we reached out on the 15th of November, and at that time, the complainant stated she was fine with contact and that she did not believe the defendant would harm her. So she's fine with contact as of November 15th. We can reach out again if you would like us to.
Please.
Yes, Judge.
So for now, do me a favor, if you just mind, just take a seat in the jury box. We'll be back with you here shortly. Or actually, let me have you sign a reset and then we'll get you back in the jury box. Why do we have her in custody? What happened? Okay. Gutierrez. All right. Good morning, Ms. Gutierrez.
Good morning.
Ma'am, you were charged with driving while intoxicated, second offense. The reason that we are taking you into custody now is that it looks like you're on probation for a felony retaliation case, which is now set at no bond. So we're going to do probable cause here today. If there is enough,
I'm sorry, I can't hear.
you're on felony probation. Looks like a warrant has been issued in that case. Bond is set at 0. So we'll do probable cause here. If I find probable cause, well, either way, we're going to, provide your lawyer today. But for now, we'll do probable cause on your DWI second. You're facing up to a year in jail and or a $4,000 fine, man.
Yes, Judge. The officer initiated a traffic stop in Harris County, Texas, after observing the defendant failed to yield to a right-of-way in an intersection and for driving with an expired registration. Upon contact, the officer observed a moderate odor of an alcoholic beverage and slurred speech. The defendant admitted drinking 2 beers and Stanfield's sobriety were conducted. HGN 6 out of 6, walk and turn 5 out of 8, and the defendant refused to do the one-leg stand. The DIC was read and breath was consented to. The results were 0.139 and 0.146.
All right. Have you seen whether she has a valid Texas driver's
Not
license?
eligible, Your Honor.
All right. Ms. Gutierrez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now, as a condition of your bond, not to drive. It is a condition of your bond, and you will be signing an affidavit with me today promising you're not going to drive. I don't care what's going on in your life. If you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Now, I don't know if you're going to get out of custody, but if you do, you will be required to obtain a handheld interlock device that you're going to take with you to prove to me that you're not consuming alcohol. We will also be sending word to DPS so that every officer in the state knows if you're in a vehicle driving, you will be required to have an interlock in that car. So if they catch you driving hard that doesn't have an interlock on it, you're going to be going right back to jail. You understand? No alcohol, no drugs, and I'm going to randomly test you as well. We will provide you a lawyer today so that you can talk with this person to figure out how we go forward with the case. All right, come on. We'll have you sign this, and then we'll have you sign your conditions, ma'am. Good morning, ma'am. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The complainant and the defendant are in a dating relationship as of 6 years. And on December 28th, 2024, the officer is dispatched to a disturbance at a residence in Harris County, Texas. The officer met with the complainant who stated he was assaulted by the defendant at around midnight that morning. The complainant stated he and the defendant had been at a comedy club and the defendant was drinking. An argument ensued and the complainant began gathering his belongings and the defendant punched the complainant in the face with her left arm, making contact with the center of his face. The complainant said the defendant also slapped him with an open fist on his right cheek twice, causing pain.
Got it. All right, ma'am, I'm going to find that there's probable cause to go forward with the case. Do we know whether he wants to have contact or not? You guys reached out to him?
Rip was attempted this morning, but unsuccessful.
Okay. Because I don't know what this person wants, I'm ordering you not to have
Have
contact.
a contact or no contact.
Stop. Don't say anything. I'm just telling you what the expectation is so you know, because if you violate these conditions or if you pick up a new case, I'm going to revoke the bond. We'll put you in jail. No more PR bonds. So no contact, no weapons. There is a protective order that has been issued in this case. Get to know it, because if you violate the protective order, they can file additional charges against you. You understand? So what we're going to do now is I'm just going to have you sign a reset with Victoria. We'll have you take a seat in the jury or wait for your lawyer to get here.
He's not gonna come. They've already contacted you guys and let you know he's out of town and he'll be back on the 9th. They said I just needed to come and sign my bond conditions.
Okay.
It's Maverick Ray.
Contact and no weapons.
Yes, Judge.
All right. So what we'll have you do is we'll have you just take a seat. We'll have you sign a reset. And I don't know, perhaps did you hear from Maverick at all?
No. They did try to reset. I said there would be bond conditions for her.
Did they give you a good date?
I think he's back on the 9th.
18 months out, and we could do work for them.
Got it. Okay. So we'll have you sign a reset and we'll just have you take a seat at the jury box.
Yes.
Please. Okay. What was the last name again?
Simmons-Berger. Page 11 and 12.
You picked up a new case, Miss Simmons.
Simmons
Irvin. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with the offense of criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine.
Yes, Judge. The officer is dispatched to a club in Harris County, Texas in response to a disturbance. The complainant, an employee of the club, told officers that she had asked the defendant to leave and the defendant refused. The defendant had been trespassed by another officer the day prior, and the complainant stated the defendant continues to return to the location. During the incident, when the complainant told the defendant to leave, the defendant stated, "Leave me alone or I will hit you in the head." The defendant told officers that everyone at the location was trespassing and that she should have been given a pink paper in order to be trespassed.
Okay, ma'am, I'm going to find that there's probable cause to go forward with the case. You've picked up a new case. The only thing I asked you to do was not pick up a new case, and now you've done it. So what happens now? Corey?
Judge, I'm going to ask for you to allow her to remain on bond. The state hasn't filed, if that's what you're getting at. The state hasn't, the state hasn't filed a motion to revoke bond. I'm not prepared for it. If they have, ask for time for a hearing to be set, so we can, have a hearing based on evidence. She hasn't violated the bond conditions, from the previous case as far as they relate to going to the
She
housing
has,
authority.
though. One of the conditions is behave yourself, give no facts arise to probable cause that you violate any new laws. She's now picked up a new case.
What is related to your very specific orders about her not to go back to the address where her apartment was or the Houston Housing Authority address. She's complied with those terms.
But if I let her go now, that's enabling this behavior and telling her it's okay.
Well, Judge, I think it would be punitive if you put her in jail as opposed. Well, that's not the purpose of bond, right? It's community safety and the community.
She's threatening people allegedly there to beat them in the head. She won't leave.
That's hearsay. Let me just talk.
Taking you into custody, man.
Judge, that's hearsay. I think we're entitled to a hearing.
Yes, I'll give you a hearing. Sure. Whatever you want.
My arm is broke.
I don't know how else to, she's gonna do whatever she wants to do. How am I supposed to handle this?
I'm not a threat to the community, so I'm not understanding, and as I said, that is hearsay. Is there any way, can you subpoena the cameras? Because I didn't threaten anybody, and there is also multiple witnesses that was there as well.
Sure. So that's my job. That's not the judge's job, and I'll do that just like I've done for the previous case.
So,
Judge, can we allow her to remain on bond until we have an actual hearing following the rules?
I haven't been around.
Following the rules of evidence for bond revocations.
Here's what we'll do, Corey. What I'm gonna do is I'm sending you for a drug and alcohol test now. If you fail to take the test, if you fail to do what you're supposed to do, I am gonna revoke your bond and put you in jail. I'm now putting a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Hey, 1 second. I'm homeless because they had refused to let me back into my apartment.
I'm not gonna talk to you. This is not a negotiation.
No, I'm
It's
not.
either you follow the conditions of bond or I'm gonna revoke it and put you in jail.
Okay.
This is
So
better than being in
whatever
jail,
you want.
unless you want to be in jail.
Your lawyer's asking me not to put you in jail now.
For how long
You
will I be
pick
in jail?
case.
Until November the 22nd.
No, I'm sending you for a drug and alcohol test now. We are going to reset this case until Monday. You were to come back Monday so we can address it. In the
I
interim,
did consume alcohol. Not anytime soon. So that's fine.
I want you to listen. I'm going to put a GPS monitor on you and I'm giving you a curfew of 9 p.m. to 6 a.m. Do you understand?
Where's my curfew supposed to be from is the question. Because if I'm currently homeless and I am sleeping on the city streets, residing, because they refuse to let me back into my apartment, where
I don't know what you're doing.
where is that supposed to be?
That's what these conditions I'm giving you, ma'am.
It'll be within an exclusion zone. We do GPS in exclusion zones.
Sure.
Have a permanent
address
then.
But I don't. I'm ordering you not to consume alcohol or illegal drugs. And I'm gonna randomly test you, but I'm saying you now for a test, you're to come back Monday. Do you understand?
That's fine.
Okay. I'm giving you a monitor on your ankle. I don't want you going to any clubs, bars, or anything of this nature. Do you understand?
That's fine.
Thank you, Judge.
See you Monday.
Yes, sir.
And I'm sending her now for a test. I want to know what, if anything.
Where do I go to take this test?
She'll tell you.
Curfew's 9 p.m. to 6 a.m. Okay, so he's homeless, need a home base for the GPS to observe the.
That's what I was trying to say.
She's got to live in somewhere. Got to be
I
living.
don't have friends or family or nothing, so that's what I'm saying.
You put your head somewhere down at night.
Yeah, on the city streets.
We'll get an address for it. Thank you, Judge. It's better than jail.
Yeah, it's not gonna be exaggerous either.
Maybe excuse me.
Come up, Tristan Smith.
Thank you.
Let me express my extreme disappointment with you. You've now picked up a new case. Is it on docket today or no?
It is, Judge. We placed it on after we spoke.
Mr. Foster, you now stand charged with the offense of assault. You are facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. And for some reason, I don't see it.
Well, Your Honor, it's under Smith.
Well, Judge.
Tristan Smith. I'm sorry. I called you Foster. I meant Smith.
Can you, API was a 2B, so this is a longer on the video that you see. The previous one, which is the AFM, because he has 2 open misdemeanors right now.
Right. So he initially had the open assault of a family member.
Yes.
As of December 19th, he's now picked up a new assault.
Yes.
All right. Let's do probable cause
On the new assault.
on the new one.
Yes, Judge. On October 29th, 2024, an officer was assigned to investigate an assault that occurred on the 18th of October at a residence in Harris County, Texas. The officer reviewed video footage of the assault that showed the first complainant and the defendant engage each other in a physical fight until another female assisted the defendant by punching the complainant and grabbing the complainant by her hair. The female swung the first complainant to the ground by her hair, causing pieces of her hair to be ripped off while the defendant punched the first complainant multiple times in the face. As the first complainant was on the ground, the defendant stomped once on the back of the first complainant's head, and the officer observed the first complainant with injuries based on photos. The first complainant told officers that on the day of the offense, the defendant told her that he was going to assault her once she exited her vehicle, and a friend of hers that was inside the vehicle recorded the fight. The defendant and the first complainant used to be friends, and the defendant used to live with the first complainant at her residence until the defendant was kicked out.
Judge, if I can, just utilizing the state's information that they provided, and I didn't hear the prosecutor read this part, but at some point, the officer interviewed the complaining witness in the new assault. Based on what she told him is that she had heard that Mr. Smith was going to attack her. And if you just read in the DIMS, she exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. When I talked to Tristan about this last week, he told me all about it. He said, I remember this because it is a 2B. He hadn't heard nothing, any follow-up on it. This young lady got out of her car and attacked him as he was walking down the street. It says it right here. MB exited her vehicle to engage in a physical fight with Mr. Smith to defend herself from him. She's in a car where she could have easily seen him and kept driving. No, she got out of her car and attacked him, exactly like he said. And while he was defending himself against her, another individual, another female, came to assist him in this fight because he was attacked and blindsided. This is exactly what the complaining witness in this case told the police happened, except she said that, well, I heard that he was going to attack me, so I jumped out my car and attacked him first. That's not an assault.
I don't know. All I know is that the facts are pretty egregious. And I mean, he could have taken off, didn't have to sit there and didn't have to engage. He could have, you're on bond for a criminal case. So stop. I'm not asking you to say anything. You, in the correct mindset, I have an open assault. It's probably a pretty good idea for me to go away and not do anything here.
And if he had that time to reflect in that instance, then perhaps he should have done that. But he's walking down the street and this girl jumps out the car to engage him in a physical fight, like she told police that she did, to defend herself from him. He doesn't have time to sit and reflect, oh, I got a case and all that.
He could have run away. He could have gone. He could do something else. I don't know.
Being attacked, Judge, I mean, you got to do something.
Look, I get that there's always two sides to the story. But I mean, I'm going to find there's probable cause now.
I understand.
If you develop something later, if you see something on video, if you show something that she's the initial aggressor, come back and we can talk.
She said it. She told the officer.
I don't know that for sure. I mean, it just,
Let's say in self-defense.
Yeah, we have the in self-defense, and then we have furthermore that once the female was assisting the defendant, that the defendant continued to assault the complainant, even stomping the complainant on the head.
You got to stop her if she's attacking him.
Well, Judge, she was down on the ground. The complainant
Yes, Judge.
was down on the ground, and the defendant stomped on her face.
I'm finding that there's probable cause. You picked up a new case.
And we'll deal with that, Judge. But the biggest issue, of course, is the fact that he did pick up a new case, albeit he didn't ask for it. I mean, he's walking down the street. And his situation being one that's extraordinary, one that I haven't seen much this year, dealing with indigent defendants, being of his age, which is a high school student, as we've talked about before, pending graduation with an acceptance to a great school. This is a very tenuous time for him. You've already ordered him to be drug tested before and all of that. So we're working through those things. the last thing that, and I know we have to consider the complainant witness in the community and all of that. I understand that. But I'm advocating for Mr. Smith.
I get it.
Mr. Smith has a final on Monday that he must take. If he does not take this final, and he's again in high school, then he may not graduate. If he doesn't graduate, then we can kiss Baylor goodbye. It's not likely to happen for him in light of all of the challenges that he's dealing with. He doesn't have his mother to help him. His grandmother, we know she's a complaining witness. He can't even go around the house. He doesn't have any help right now. He's living with a friend and walked here from Atascocita this morning, which took him 9 hours. I mean, this situation it's extremely difficult, Judge. So my ask is that we do something, and it could be amend bond conditions, but to keep him on bond so that he can take his test, do what he needs to do to finish school, and hopefully we can resolve these issues. I've looked at the evidence that the state has submitted for the new case. There's clearly something happened, clearly. I mean, and I see the evidence shows that. But if he's walking down the street and this girl, per her own admission, jumps out her car to engage into a physical altercation with him to defend herself, that doesn't make sense. And that's not really fair to him. Someone that's on bond, and everybody knows he's on bond because she said, I knew him. We used to be friends.
He could have walked or run away, gone to a store, called the police. There were a multitude of other options you could have done. You know what's at stake here, yet you pick up another case where you allegedly stomp on someone's head. And you want me to let you go? I understand that you have school. I don't know that you have a final on Monday. Am I supposed to take your word for it? No. All I know is that you are a danger to my community. You have one assault. You have had violations on bond while you're on that assault, and now you've picked up another assault. You are a danger to my community. And there's only one thing that I need to do, and that's to put you in jail because you refuse to comply with bond conditions. And I've given you over and over. I appreciate your tenacity, and I love that you're defending zealously, but I can't let him go. It would be enabling this behavior and telling him it's okay for you to do what you're doing. And it's not. It's not okay to sit there and stomp on someone's head.
And Judge, we anticipated that possibility. I'd ask in the alternative that you consider a very low bond, as my client has approximately $100 to his name, being a child in my mind, a person that hasn't even graduated from high school.
State of Texas, what do you think?
Judge, we would be opposed to that. I mean, given the egregiousness of these facts, we believe the defendant is
I won't do the normal. What I normally do is I set bonds at 5,001 when you pick up a new case. I'm willing to go down. I'm not going to give them a $100 bond because that's what we do on new cases.
I'd ask for.
And I think that that's a little.
So we're going to revoke the previous bond that was a personal
And
bond.
we'll only touch the old case.
And so, or we'd ask that. I didn't anticipate that you set a personal bond on the new case. So I guess my request would be $500 bonds.
Oh.
I mean, we're talking about a misdemeanor assault between children, not a.
Well, I don't know that. I mean, you're putting in stuff that I have no
The
idea
state
about.
alleged a misdemeanor assault. They didn't allege an aggravated assault, which they could have, and they did not. They alleged a misdemeanor
Doesn't make
assault.
me feel better.
The state says, alleges that there's all this injury. We can see what the injuries were. You see the complainant witness in the picture. She's smiling.
She go
as
to
she's
the
talking
hospital?
the police. No, she didn't go to the hospital, Judge.
I don't know.
I've read everything. She hasn't gone to the hospital. She has a swollen eye, is what she has.
Judge, I don't believe, I mean, her hair was also ripped out, Judge, based on what we see in the four corners of the dims. We haven't done.
I don't know. I mean, there's a lot of people who wear different types of hair.
Sure.
So,
But just going off the dims, we have her hair being ripped out and being stomped. So,
and to your question, not hospitalized, Judge.
so here's what I'll do.
Judge, just if I may add, even in the first AFM, Judge, the complainant has gone back to the home at least once, to my knowledge, based on my communications with the complainants on that case. The defendant has gone back to the grandmother's homes, contrary to the bond conditions and the no contact orders in that case. He's repeatedly, time and time again, violated his bond conditions, and now so we would be opposed to anything less than $1,000.
Yeah, I know. So what I was going to, his bond on the first assault is when it's $1,500. I'll do 2501 on that. Okay, I'll only raise it at $1,000. On the new case, what do you think? Should we give him a PR bond?
Judge.
No, Judge.
We'd be opposed based on the nature of the allegations where he stomped on someone's head, pulled her hair, and in addition to that being picked up just a month after the previous AFM.
And charged with a misdemeanor. I mean, if the state felt so vigorously about this case, then they would have filed it in district court. I mean, this is a misdemeanor assault between.
I think there's no way this would have been gone upstairs. You know.
I agree, and which is why I think a personal bond could be adequate in light of the fact that he would be given a surety bond on his previous case. He doesn't have much, if anything. If anything, that keeps him in jail until we get to trial, because that would be a case that we would set.
All right, Mr. Brooker, I'll set the new one. I'll set it at $500.
Thank you, Judge.
I hope you get it. You're going in today, but I hope you get it. I mean, we're not going to stand for this. You got to pay the piper. And I don't know if it's dealing with the school now will get you to wake up and realize that you can't do what you're doing, but that's it. You know, I've literally bent over backwards not to put you in jail, Mr. Smith. Literally bent over backwards. How many chances have we, it goes with you. Okay, Mr. Smith, good luck. Good morning, Mr. Harvey. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was parked and observed a road rage incident occur. The officer observed the defendant's vehicle laying on his horn and speeding up to cut off another vehicle. The officer observed the defendant slamming on his brakes, and the driver of the other vehicle then attempted to drive around the defendant when the defendant cut her off again and slammed on his brakes, nearly causing her to drive into a ditch and nearly causing an accident with other vehicles. The officer then initiated a traffic stop and pulled into a nearby parking lot.
Mr. Harvey, I'm going to find that there's probable cause to go forward with your case. Patience. Patience when driving. And I'm going to have you sign a document promising me that you're going to exercise this patience and not drive in this manner again. And if I find that you do, I'm going to put you in jail. Do you understand? Those conditions like we did in the other case.
Yes, Judge. Yes, Judge.
Harvey, we were going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. We'll then have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. Wait, does he have a Texas? Can you run his license, please?
All right. I see eligible on RN. I can run it again.
Please. If you do not have a Texas driver license, then do not drive. I will have you sign an affidavit today with me promising me you're not going to drive unless you have a valid Texas driver license and liability insurance. It is your responsibility to reach out to DPS to figure it out. Do you understand?
Yes, I see eligible on our end.
Okay, I'm going to have him sign it, and then if you have a license and liability insurance, you can drive. If you don't, then don't. If I catch you doing it, it's not going to go well for you. You understand? Okay. You ready?
Yes.
Come on up. Hey, how are you? Mr. Stewart, what's new?
Sir, how was your new year?
Great. We did PC on your case.
Okay.
We just did stand up. What's your guy's name?
My last name is Alan, Your Honor. I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear it. So refresh my memory. What happened?
So in Alan's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The defendant,
he had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there were other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there were other vehicles.
Go ahead.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here elucidated is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of, the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to stop him. This is insufficient information. And I would argue that there's not valid probable cause here on this case.
I think he has a valid point where, perhaps he's, well, I mean, I don't want to speculate. And you're saying, well, maybe he did it because of this, but I don't want to speculate, right? Because were there other cars? I don't know. Was it dangerous? I don't know. I mean,
Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for a stop.
right, but you got to articulate facts as well, right? So according to the statute.
Right, and I understand because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is sufficient for a stop.
I disagree. I think that when we look at the statute for trying to maintain a single lane, the second half of the statute is that it endangered somebody. And there's no indication here that there was any danger.
It's 545.060, isn't that it?
545.060, Your Honor. Section A2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely.
I also have the list of, where under Texas law where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic.
Let's do this. I mean, this is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go?
Oh, yeah.
Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time.
Yes, sir.
Right? Give you time to take a look more so if you need to, you two as well, if you want to try to find a case law. Let me just go through because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah.
State has emailed me some cases that they wanted to cite to.
Morgan.
Judge.
Someone else wanted to speak to that.
If we may, upon reviewing case law, so as we've discussed before, so he did veer into the shoulder and then go back onto the lane. And in Hardin, failing to maintain a single lane with the added vehicle component is the danger that they provided in the case law that makes failure to maintain a single lane, unlawful. Furthermore, in cases such as Lamming and Martinez, the court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is the time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was at midnight as well.
No, but one of the things is there's an element of unsafetyness, right?
Yes, and Your Honor, there are other vehicles around. As the officer articulated in the dims, there are other vehicles around when he veered and then jerked back into the lane, as the officer put in the dims.
But I get it. But where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
And furthermore, Your Honor, what he did articulate into the shoulder, and upon looking at the statute for that, the Court of Appeals in Lothrop v. State articulated that there are 7 permissible reasons to go onto the shoulder, and there is reasonable suspicion to perform a traffic stop where there is not one of those permissible reasons. And here, the officer did not, with those other vehicles saying he passed the green light and then go halfway into the shoulder and then jerk back, it implies that there is not one of those 7 reasons to allow another car to pass, to stop or park, or to accelerate before entering the main lane of traffic, or decelerate before making a right turn. None of those are present. None of the 7 reasons articulated in the statute on the Transportation Code 545.058 are present. So that alone, him going into the shoulder without a permissible reason, is enough to perform the traffic stop. And that taking that into account with Hardin, which he veered out of. He failed to maintain a single lane with other vehicles around, provided enough of a community danger to allow the officer to perform that initial stop.
Where's the danger?
It would be the other vehicles present, Your Honor.
He doesn't articulate that, though.
He does articulate that there are other vehicles.
All he says is there are other vehicles.
That is all the case law requires. He doesn't have to say there's a vehicle right in front and right next to him. The case law requires that there be other vehicles within the vicinity for it to be.
Right. In the case law,
I don't know if it's in the vicinity, though. All he says that there are other vehicles. That's so vague. You say other vehicles in the vicinity. He doesn't say that they're in the vicinity. He just says there are other vehicles, and that's so vague and conclusory.
Your Honor, the case law does specify there only needs to be a minimal level of justification for the stop. In this case, that is enough where there's other vehicles around to provide that additional threshold for failing to make a single lane. In addition to no permissible reason to enter the shoulder, there's nothing there to indicate there is a permissible reason.
If we're taking outside of the failure to maintain a single lane, and we can go into the other part of the transportation code that this defendant violated, which is veering onto the shoulder, he did not do so for one of the 7 permissible reasons, and thus the officer has reasonable suspicion to stop him.
If you're veering, that is 545.060, right? Isn't that part of your, that's the weaving, right?
It's a different one.
Because you just said there's another violation of the transportation code.
Yeah, and it's under 545.058 is for entering the shoulder.
Right.
May I address the court, please, Your Honor?
Hold on, let me pull that code up. So that's
545.058.
The transportation code.
All right, let's see. That is driving on an improved shoulder. An operator may drive on an improved shoulder to the right of the main traveled portion of a roadway if that operation is necessary and may be done safely, but only if to stop, stand, or park, to accelerate before entering a main travel lane of traffic, to decelerate before making a right turn, to avoid a collision as permitted by an official traffic device. Okay.
Yes, Your Honor. So in terms of their arguments about the driving on the shoulder under Lothrop, their case that they're citing, the case itself says, and I quote, merely driving on an improved shoulder is not prima facie evidence of an offense. That's their case. It says that doesn't benefit them at all. In terms of Hardin, their own case, based on our review of the record and precedent, we conclude that the detaining officer did not have reasonable suspicion to stop at belief for violating Transportation Code Section 545.060. Again, that's their case. And in that one, that's where the vehicle's tires crossed over the fog line, just as in our case, into the shoulder. And in their own case, it says that was not reasonable suspicion. And so, I would like to, highlight these two cases because I think they're directly on point. I don't know why the state did. In terms of State v. Hernandez, which is 2016 out of the Fourth Court of Appeals, and I have the appellate case number, but I don't have the specific site.
My only concern is there an element of safetiness? That's all I want to know.
To just address one point briefly, in the case Lothrop, they do say that really driving on an improved shoulder is not prima facie case evidence of an offense. However, if it states explicitly that the offense of illegally driving on an approved shoulder can be proved in one of two ways, either driving on an approved shoulder was not necessary part of achieving one of the 7 approved purposes which are articulated in the statute, or that it could not have been done safely. And here, we're again going back to the 7 articulated purposes in the statute that are not present here. He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory, then, any single person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code. This law can't be like that.
It wasn't just announced. He went halfway in. So he veered halfway into the shoulder. It wasn't just like a little deviation. He said, the officer said halfway into the shoulder and then jerked back into the lane. So he went out and then came back into
So are we supposing that that's like half a second of driving on an improved shoulder? Is it 1 second? Is it Is it a minute? Is it?
Should matter. I mean,
Because the legislature articulated 7 specific reasons why that would be permissible, and they wouldn't have.
If an old grandmother who's 70 years old is driving on a freeway and accidentally,
And that's, but that would provide the minimal justification just to perform an investigatory, a stop, just to investigate. It wouldn't be an arrest or anything like that. It would just be the traffic stop would be allowed at that point.
I don't know. I don't think that the officer wrote enough in the report. I don't think that the unsafetyness as far as, saying that there are other cars around. I just don't think that there's enough.
Yes, Judge.
I'll find no probable cause.
Thank you.
Okay. Have you signed on yet?
Yes, sir.
Good morning. Great to see you. How are you? Always a pleasure. All right.
Pleasure's always mine.
Mr. Barajas, you are charged with 2 counts of assault of a family member. You're facing up to a year in jail and/or a $4,000 fine on each. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you have the right to have an attorney present, if you cannot afford one will be appointed to you, sir.
It's my understanding that the state's going to dismiss one of the, it's the same registry file. That's my understanding.
Okay, good to know. Thank you. Sure.
On December 29th, 2024, the officer was dispatched to a residence in Harris County, Texas, and was met at the front door by the complainant. The complainant stated that the complainant provided a statement and brought the officer into her kitchen, and the officer was able to see redness on the upper left side of the complainant's face near her eye. The officer also observed on the complainant a small laceration and fresh blood. The complainant had tears in her eyes and stated that the defendant and she had been in a dating relationship for on and off for 6 years, and that in the morning, the defendant and she got into a verbal argument about various issues, and the defendant became irate due to her confronting him about the issues, and he started belittling her and calling her derogatory names. The complainant then stated that when they were arguing, she responded by insulting the defendant back, and then things began to intensify. Eventually, the defendant charged at the complainant, and the complainant stated that the defendant slapped her with an open palm across her face, throwing her backwards onto the bed. And as the complainant attempted to cover up her face by turning on her stomach, the defendant punched her in the back 3 times with a closed fist, and the complainant did feel pain from being slapped and punched in the back.
Okay. Mr. Barajas, I'm going to find that there's probable cause to go forward with your case. I'm entering now what's called a magistrate's order for emergency protection. This identifies Ms. Alvarado as a protected individual. You cannot commit family violence. It's okay. It's not a big deal. Are they prescriptive?
Yes, sir.
Back on. I want you to understand that I'm issuing a protective order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, Your Honor.
If you violate this, the state can and will file a violation of protective order against you, and it's one of the worst cases you can pick up. Just don't have any contact, don't have any weapons, and you'll be fine with us. Got a great lawyer. Listen to him. He'll take care of you. Because you have a lawyer, I will waive your appearance, but you have to stay in contact with him. If he comes back, tells me he can't get a hold of you because you've taken off, a warrant will be issued. You pick up a new case, a warrant will be issued. It's not hard. Do you understand? Do you understand?
Yes, Your Honor.
Okay. We're going to have them file all the documents. We'll have you sign it, and after that, you'll be free to go. Okay? Do you want a PR bond?
I just didn't want to fight too much.
Of course.
Yes,
Please. I just see the stuff from 92. That's all I see, right? Is that it? Okay. I'll grant you a PR bond, but understand, this is the only one I'm going to give you. You become a danger to my city. You become a danger to my community. I'm going to yank that PR bond and I'm going to make it high. You understand?
Yes, Your Honor.
It's not hard. All right. Okay. There's a ton of paperwork we're going to have to do. So just pick a date with Victoria and then you're good. Don't leave until you sign all the paperwork, Mr. Rojas. Okay? Okay. Good morning, Mr. Martinez. Mr. Martinez, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27, 2024, the officer was assigned to a traffic crimes task force and followed a group of 40 to 50 racers from 2400 block of Turning Basin to the 610 loop. The officer...
40 to 50 racers?
Yes, Judge. And the officer observed the defendant and co-defendant's motor vehicles in lane 1 and 2 slow down to approximately 30 miles per hour, and both vehicles took off side by side, trying to outpace each other at approximately 100 miles per hour. A traffic stop was conducted, and the officer made contact with the driver, the defendant, and he was the sole occupant of the vehicle.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has a valid...
Not eligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive, and I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing every time you drive. It's an offense in and of itself, punishable by up to 6 months of jail and a $500 fine. Do you understand? Do not drive. Whenever you fill out the affidavit promising us you're not going to drive, we will get you to Victoria, sign a reset, and we're going to get you out of here. When you come back, please have a lawyer. Sir, you are charged. Do you speak English? Yeah. Yeah, no.
John.
Better. You're charged with reckless driving, up to 30 days in jail and or a $500 fine. Hey, Conrad. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
I apologize, Your Honor. What's the last name of this?
Turu Biartes. Turru.
Thank you, Your Honor.
Sure.
The officers were surveying a known street takeover group in a large parking lot in Harris County, Texas, when the officers observed the defendant's vehicle spin its rear tires and do approximately 4 to 5 donuts in the pit, coming within 10 to 15 feet of other vehicles. Undercover officers kept their eyes on the vehicle until other officers were able to conduct a traffic stop. The undercover officers also identified the driver as a slim Hispanic male with curly hair. The officers observed the defendant in the driver's seat and the defendant admitting to doing donuts.
Right. Sir, I'm going to find that there's probable cause to go forward with the case. Have you seen if he has a valid license?
All right, Your Honor.
Please. I'm ordering you as a condition of your bond not to partake in this type of behavior again. No racing, reckless driving, donuts, street takeovers. If I find that you do, I'm going to put you in jail. No more PR bonds. Do you understand, sir?
It's eligible, Your Honor.
Okay. Do you mind crafting those orders? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. We'll get you in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Be careful. Don't drive like this again. Do you understand?
Yes, Your Honor.
Good morning, Ms. Wallace. You speak English? Okay. Ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 27, 2024, the officer was dispatched to a disturbance at an apartment in Harris County, Texas. The officer made contact with the complainant, and the complainant and the defendant are cousins. The complainant and the defendant do not live with each other, and the defendant was staying with the complainant for a couple of days. The complainant stated she and the defendant got into an argument about the defendant's lifestyle. The defendant became upset and started to throw the complainant's belongings out of the apartment. The complainant and the defendant continued to argue, and the complainant tried to open the door to retrieve the belongings, and the defendant grabbed the complainant's arm, applying pressure and scratching the complainant's arm, causing a deep cut, bruising, bleeding, and pain. The defendant stated she had been arguing with the complainant earlier in the day, and the defendant stated she got fed up with the complainant criticizing her and asked the complainant to leave. The defendant stated the complainant pushed her and took her phone, and the complainant's small dog caused an injury, and the defendant did not recall injuring the complainant.
Do you know if alcohol played a part in any of this?
There's no allegations, Your Honor.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant will be issued. You will go to jail. No more PR bonds for you, ma'am. We will do that. We'll give you time. Yes, we're going to do that now. I'm going to have you sign a reset with Victoria. We'll give you 30 days. but I'm gonna have you also take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go, man. All right? Please. You are Brett Ware? Mr. Ware, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. On December 28th, 2024, the officer was dispatched to a robbery that just occurred in Harris County, Texas at a restaurant. While en route, the officer observed males walking on the south side of the store where the robbery had occurred, matching the description the reportee provided. The officer called in an attempt to contact the two individuals and located the two males wearing dark hoodies, dark pants, and shirts tied to their heads that looked like makeshift ski masks. The officer made contact and asked if it was okay if they were patted down for weapons, and both individuals ran off. A short pursuit lasted approximately 50 feet, where the co-defendant slipped on a puddle of water, and the defendant ran approximately 5 feet before being grabbed by the officer. The defendant, 19 years old, whilst trying to stand the defendant on his feet to walk into the patrol vehicle, the officer found on the defendant a loaded Glock 9mm, which fell out of the pant leg of the defendant.
So this is part of an ag rob as well, right?
Amanda Martin.
Yes, Judge.
What happened on the ag rob?
One moment, Your Honor. So, during the ag rob, the complainant stated that while he was walking into the store to grab his food order, the two males stood outside the store watching him, and as he walked out of the restaurant, they blocked his path, and one of them pulled out a gun on him, and the other yelled at him for his wallet and keys.
Where is this?
It was, one moment, there's an address, but not a name of the business. At a Sonny's food store.
Got it. Mr. Ware, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. I'm now also giving you a curfew. I don't want you out in the middle of the night. And I'm going to put a monitor on your ankles so I know where you are at all times. Do you understand about it? If I find that you're a danger to my community, I'm going to lock you up and I'm going to make your bond so high. Do you understand, sir? No contact with the co-defendant in this case and no weapons as well. How old are you, sir?
19.
Did you graduate from high school?
Yes, sir.
What are you doing with yourself now? Are you working?
No, sir. I was planning on going to the military. I was on to a military.
I want to know what you're doing with yourself. If you're working, if you're doing anything, because I want you to get a job. Too much time on your hands, you become self-destructive. You need something to do.
Forklift license. And I'm going to the class for forklift.
Good. Get it done. You need to get a job, and I want to make sure that you're going to get a job. I'm going to provide you a lawyer today, but I want to see here within the next couple of weeks what you have done to get a job. If you've done nothing, life's not going to go well. Do you understand?
Sir.
In this life, you have to be productive. You have to either get yourself an education or get yourself a trade, a job, because I'm going to tell you now, when you turn 40, if you don't have a career, if you don't have an education, if you don't have anything, this life is not going to be a good one for you, because I'm going to tell you, life sucks without money. You need money, otherwise it's going to be just a rotten toilet of an existence. Do you understand? So we're going to make sure here you're going to leave better than you came. So you must either get a job or get into school full time. Do you understand?
Sir.
I'm going to give you a lawyer today, and I'm going to bring you back in 2 weeks, and we'll see what you've done with yourself.
Sir.
All right? Todd McLean.
Sure.
Mr. McLean, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The officer was dispatched to an apartment in Harris County, Texas in response to a disturbance. Prior to their arrival, the officers were told the defendant was in an altercation with the child's mother, was intoxicated, and had a firearm. Upon arrival, the officers observed the defendant banging on the door to his residence, and the officer told the defendant to show his hands, and the defendant ignored them. The defendant then pulled his handgun from his waist to show the officers that he had it, and then placed it back into his waistband approximately 4 times. The defendant eventually put the handgun down, but told officers they would have to tase him to get him to stop. The officers then attempted to detain the defendant, but the defendant continuously pulled his hands away and kept placing them in his pockets. The defendant was then tased twice, but kept putting his hands back into his pockets. The officers were eventually able to detain the defendant.
Did you say, initially you said he was intoxicated, right? Is that what you
Yes,
said?
reports he was intoxicated.
Okay. Mr. McLean, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs and not to be in possession of weapons. Do you understand? What do you do for a living, sir?
Photographer. Do photography.
Okay. What kind of income do you have from photography?
Income coming in, what you want to know, monthly?
Yeah. And do you have the ability to hire a lawyer?
Yes.
Okay. We'll give you time. So I'm going to have you meet with Victoria. We'll have you sign a reset. I'll have you get with Fleischer for your bond conditions. After that, you're free to go. All right? Please.
We're prepared for argument.
Okay. Morgan, are you ready?
Yes, Judge.
This
This
is-
is Biagos, correct?
Yeah, it's here. Go for it. Okay. Ball's in your report.
Your Honor, Mr. Biagos, when he climbed to the mailbox pole, he didn't stop. He got out of the car. There's no one to talk to. And so from there, he went to his residence, Your Honor. But, it's not a case where he didn't identify himself or anything. And then we don't know what the restitution amount's going to be from the mailbox.
My concern was that according to the statute, right, it says that you're supposed to, I don't even
Take
know.
reasonable steps to locate and notify the owner or person in charge of the property of the collision.
What time, was this the middle of the night?
$1:50
in the morning.
I don't think it'd be reasonable to knock on anyone's door. I don't think anyone would open it.
I mean, reasonable steps, you know where the person lives, you hit their mailbox. It would be pretty easy to walk up and knock on the door.
Is that reasonable? I mean, if you go up to someone's door at 2 a.m. and you start knocking on the door, are you going to scare the,
Probably, Judge, but I would want to know if it were my mailbox and somebody ran their car into it.
Would you open the door and go out?
I would look at the people and I would see,
I
and then I would
guess
see a
there are other measures I guess you could take theoretically.
Some
Right.
I guess leave.
maybe leave a note on the door.
Okay, all right. Mr. Biagos, come up. I mean, reasonable measures, right? And I guess that would. Have you run his license, see if he has a valid taxi driver license?
It's an out-of-state Florida license that appears valid in our system.
Okay. Mr. Biagos, I'm going to find that there's probable cause to go forward with your case. I'm ordering you not to drive any vehicle unless you have car insurance in your name. Do you understand? If I find that you're driving without a license and or liability insurance in your name, it's not going to go well for you. Do you understand? Okay. You've got a lawyer. Listen to your lawyer. He'll take care of you. I will waive your appearance so you don't have to waste your time coming to court, but you have to stay in touch with Mr. Famine. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you or you pick up a new case, I'm going to revoke your bond, put you in jail. No more PR bonds. You understand? Okay, guys. Any conditions you think?
Judge, just no driving without insurance.
Yeah, just be careful out there, okay?
He doesn't have insurance. Can you rip the CW?
Yes.
And then we can settle it.
You did have insurance? Hopefully. Okay, wonderful. Right. Okay, all right, man. Take care. Have fun. Kevin
file
Diaz is on the docket today.
Yes, Judge.
It's,
This is the one with the Montgomery County case, right?
he's got a theft with us in court 5. It looks like he also has a theft out of Montgomery County. Is it a misdemeanor or is it a felony? Can you run an NCIC line? Because the only thing I see here, it doesn't tell me what.
And Judge, she'll run that, but I was disappointed on it. It's a misdemeanor theft at a Target.
Okay. I'm happy to, you want a bond reduction is what you want?
I would, Judge. He was taken in on the 31st on a misdemeanor theft. He's been
Here's your position.
Last name again?
Diaz, Kevin Diaz. The thing is this, is that normally what happens is we get these out of county cases. They sit there for 10 to 11 days. And if the other county doesn't come get them, which is nearly always, I mean, I'd say probably 90% of the time they don't come get them, we release them. And we just give them a PR bond. I do it, I mean, don't we do it on a daily basis now? We have so many.
5 cases there, but this is still
Hey, Steph.
temporary.
I don't see it on the TCAC. Is it in warrant status?
Yeah.
Yes.
Oh, that's fine.
He can still make bond on it though.
Yeah, he can post it in Montgomery County. Yes.
Right.
But I
But
suppose,
would our reduction reflect it in Montgomery County?
so they would have to post bond with our sheriff's department to let them go. So
I don't know. What say you? Is it a misdemeanor? Is it a felony?
Status, so it wasn't showing up.
I think so.
I just want to complete the case number so you can look it up on the clerk's website.
Is that what you're doing?
Oh, Your Honor, it's a misdemeanor. I pulled the
Okay.
information. It's a misdemeanor.
10,000 is high for a misdemeanor. So are you okay with 5?
But in,
I requested two. It's a class A misdemeanor theft. I get that he picked up another one here, but he's been in jail since the 31st. He got picked up on his birthday. He's been sitting in there in jail ever since.
5 is fine.
And I just request 2, Judge.
I feel like I'm negotiating against us. You want, what did you want?
$2,000.
2,
Yes, Judge.
5? So let's split the pup. Okay? Happy?
3.
Split? So 35. 35.
Okay, Judge. Thank you.
So Trey, do you mind? Georgette,
yes, Judge.
sorry to see you go. It's been a great time. Morgan, I think that we're gonna somehow kind of keep you, maybe.
She
Right?
might. They might.
Because I hear, right, and I know Conrad is moving up. You're taking his place.
maybe. I can't say for sure,
Oh.
but they brought more of us in, so instead of us having 4 courts, it'll be us having 2 courts of first. Yeah.
So nice.
I haven't seen, in my time, I don't think I've ever seen, like, there was an exodus, and now you have, like, so many people coming back. You know, so many friends that I have, like, I see on Facebook where they're, hey, I'm back at the office, I'm back at the office. I mean, I probably at least 5 different people are back at the office now, you know, which is great because, you know, they were great prosecutors and, you know, you never want to see someone do that though.
People that they come in and out, Judge.
Yeah, for sure, of course.
Thanks so much.